Judge back. Apparently, he was sick. Then we have some weird rule of completion that the judge denies. The prosecution wants in completely new DNA evidence. That and more in today's show. Yeah, today I've been listening in on and off on the Young Thug trial, which restarted today after Judge got sick for a few days. So no court Wednesday, Thursday, or Friday last week. So we now know that these proceedings will be at least 3 days longer than expected. And I'm going to go right into it because in the beginning of today, the defense does what the judge asks. Bring stuff in so I don't have to rule on it later when it's too late. Let's see what happened.
Appreciate it, sir. Yes, sir. Just to put this on your court's radar, I just wanted to, I thought maybe there was a little time here. There's a few things. I received this past week, and I don't remember the date, but it's electronic. I could tell you if you're interested. From the prosecution, specifically the Honorable Mr. Brown, and he sent a DNA report and a DNA witness. It deals with Act 5, 6, and 7, overt Act 5, 6, and 7. It deals with Adrian Bean, B-E-A-N. Mr. Williams is not charged in that act. We will be objecting to any mention of Mr. Williams. But this DNA expert is not on the state's witness list.
How about that? Prosecution is trying to sneak in new evidence. This trial has been going on for well over a month. And they keep trying to sneak in new evidence. In my personal opinion, this trial has the prosecution team and the judge on one side and the defense on another, in my opinion.
700 plus witnesses, nor what the court ordered to pare down. And I never received, nor did anyone else, to my knowledge, if I'm wrong, please correct me, the DNA report of this expert. So I've never consulted with a DNA expert because of that. So I'm moving to exclude any DNA mention
down, Mr.
and the report and the witness. That's one thing. And then I gave your Honorable Court co-worker, the Honorable Mr. Kearns, just a printout. You already ordered this, Your Honor. It was dated November 17, 2023, but all experts, it's in the second paragraph, it's a one-page order, all experts' reports, analysis, findings, and the basis for same must be provided to counsel for each person in stanter. And you cite Harris versus State, which is 314 Georgia, 238, it's in Division 6A, as in Elisa Alpha 2022. And it says then, if these orders are not complied with, this Honorable Court will entertain any and all lawful sanctions. So that is my one issue, if there's time for that. A second issue, and it's related, is the state gave us what I'll call tweets. I know it's called X now, but tweets that supposedly Detective Belknap will use. And they're from Mr. Williams, I believe, Twitter account. I'm not opposing that. I don't need a foundation to be laid as long as the state has a good faith belief that these are what they say they are. I'm okay with it, but they're pulled out of context. They're just, like one.
As per usual, let's look through thousands on thousands of tweets and then cherry pick a few and make huge claims about it.
So unless there's a foundation laid, or I guess a stipulation, because I don't really need to sit here and watch a foundation be laid, but a stipulation that all relevant, though, tweets are admissible. That's fine. But most of these are character. They're just, what's up, my homies of blood? What's up, blood? I love SMM and things like that. So that is my second issue. And then finally, Your Honor, I've noticed like a theme that I'm being mentioned a lot along with the Honorable Keith Adams. Did, Mr. Stevens speak with us? Did he do anything? Did I go visit him at the jail? I have no memory of visiting Mr. Stevens at the jail, but I'm not saying it's not true because I assume the state has a good faith belief that I did. But if I did go to see him, I did not do anything inappropriate. And I did not see him recently. And I know the state didn't say I did anything appropriate, but it's just this constant, like, Mr. Steele, did he ever come to see you at the jail? There's nothing wrong with seeing a person at the jail if it's true what Mr. Stevens said. And again, I don't have a memory of this. And I looked at my diary. I don't have it on my diary. But I don't have a year. I just don't know when this supposedly occurred. But he has a probation revocation case. And you ordered that any time that I'm going to be mentioned, or I'm now including Mr. Adams, the state has to bring it to your attention why it's relevant and outside the presence of the jury. And I don't think that was going on. From opening statement where I had to ask for a mistrial because my name is there representing someone who's not even here, to consistent with Mr. Stevens. So that's my third issue. And I think I said finally, but the last one is I'll be objecting. There's a movie theater incident. A person, it might have been two people actually, who shot at a movie theater. Mr. Williams was at the movie theater. He's one of the celebrities there. People came out to see him, and a lot of celebrities were there. There was a premiere of a movie. I don't have any evidence that Mr. Williams shot anybody, asked anybody to shoot somebody, was a participant, was a party to the crime. So I'll be objecting to that. And the state just gave me additional discovery on that movie theater.
The prosecution just gave him additional discovery. He was just handed. And the shooting at the movie theater, so far as I know, has nothing to do with YSL. So far as I know, nobody was charged. But underlying acts, the prosecution, with the court's blessing, can throw everything on the wall and hope to the grace of the Almighty that something sticks.
Incident that I never had before, and that was done. And I listened to it and I've watched it. And I'm not complaining. I'll absorb all the information. I don't want the state to say, as we roll this case, why didn't you tell me earlier you're objecting? So I thought you had a few minutes. And I just want to bring all of those to your attention to flag them. And that's
So
generally
4 issues? Okay.
those are generally what I'm just ask you to keep on your radar. And if you want to address any of them, I'm more than willing to.
All right, let me see what the state's response is to. So let's deal with number one, the DNA issue in terms of overt acts 5, 6, and 7. Was there a report produced, madam, and if so, when?
Your Honor, there was, and I would ask that the court allow us to, I don't know how much time we have, but number one, we're not introducing that act or evidence of it today. I believe that would be a matter we can take up at the end of today.
Postpone.
Regarding,
Still didn't answer my question.
it was. I'm sorry.
Really good about that. So my question was kind of clear. Did you get a report, and when did you get it?
I do know that we served in preparation for this week coming up. We did notify Mr. Steele that there was a report. I have to look back through records to see when we got the report and when and if.
She knows exactly when this report. It was from November of 2023. And she conveniently hands it over. Because here's the thing. If the defense wants to have their own expert, and she's bringing it up now, just now, that they will have this in a couple of weeks. That means the defense has 2 weeks to find an expert, hire that expert, pay that expert, and the expert has to go through the so-called DNA evidence. I'm only 10 minutes in. I can't say the words. But how is this even remotely allowed?
if it was actually turned over as part of discovery. Judge, I can say that, of course, there's nothing inadvertent left out. What the report is a report from a DNA specialist who says that because of the mixture of the DNA on the guns that were tested, they were not able to extract or to develop a profile from any one person because it was too mixed up. So
then how can it be relevant to this case? If that is what's in the report, we couldn't get a DNA evidence. Why even bother the court with this pile of garbage?
Okay.
We have additional arguments, and we would like the opportunity to make certain that I have no reason to believe Mr. Steele is misrepresenting anything to the court regarding whether or not he received it previously. We'd like to confirm that.
Let me know and give me the date of when you received it
Okay.
and when you turned it over.
Okay.
All right. And when's this witness going to be called?
What date do we have? Next Thursday, maybe?
Next Thursday?
Yes,
All right, so we
Judge.
can defer until that time, or close to that time. All right, so that's issue one. Issue two is these tweets, and this is the Detective Belknap.
And Your Honor, again, this is a subject that will be better served being hashed out in an argument after court today, perhaps, because it will be a little bit lengthy. But generally, our contention is that Mr. Steele is free to introduce any part of his client's tweets that he wants to. He cannot, however, dictate which portions the state chooses to put in, and he is entitled to introduce the rest of every one of the pages that the tweets come on. We do not have to. There's no law that suggests otherwise.
That's a rule of completeness. So.
Right, he's allowed.
So when cross-examination occurs, unless there's some other basis to cross, or those.
Remember this when he refers to the rule of completeness. Remember this for later.
Tweets are objectionable, then I'll deal with them as that case, as the matter comes up.
And to be clear, the state has absolutely no objection to Mr. Steele completing the record with his additional tweets. As he
That would be
sees
his right anyway, so to ask or
Okay.
to, so that's two. Number three is the mentioning of Mr. Steele and Mr. Adams. I get to in regards to Mr. Stevens. Is that to show bias? Or,
Absolutely, and
all right, okay, and or attempted bias.
yes.
All right, okay, and anything else in regards to that?
In regards to that, yes, it was fresh on the state's mind, this prosecutor's mind, when I stood up to introduce or to speak with or examine Mr. Stevens in front of the jury on one particular day, because Mr. Stevens was very adamant that he did not want to speak with any member of the state. And as we walked past, he was huddling with Mr. Adams and Mr. Steele. So and not only that, but we have the records from when Mr. Steele visited Mr. Stevens at
So you
the
have a
jail.
good faith basis to ask that question.
Yes, Your
Okay,
Honor.
all right. Number four is the movie theater incident, the premiere. When is that gonna do
What day?
testimony of that?
Mid-February, Your Honor, is when we are planning to introduce evidence of that. So I think that that's another matter that we can take up after we have completed at least this day's worth of testimony to allow us to
Okay,
expeditious about our time.
all right. So I'll defer on that until we get a little closer to that.
I defer to that when we get a little bit closer to that. That is what this judge has done since pre-trial hearings going forward, who will always defer forward. And you have seen his reaction when that time comes and the lawyers object and he gets mad every time about the timing. And here he clearly states, again for the umpteenth time, I will defer it forward.
Yes, Your Honor.
All right,
Thank you.
okay.
After court, I will make certain to get that to you today.
Let's skip forward a bit.
Whatever's going around Atlanta, you name it. So to that effect, I've ordered that
Yep.
the courtroom be sanitized.
Yeah, the judge got sick. He ordered the court and the courtroom and the jury room to be sanitized. So, good for you.
Your headquarters be.
And
Olive.
All right.
poor Mr. Stevens is back on the stand.
Now, when you are reading various lines, do you recall reading the line that my finger is pointing to on page 1700?
Yes.
Keep talking about joke. This ain't no joke. Y'all niggas ain't worth enough to cover a $1,500 rent. What's funny? Is that you talking?
Yes.
Who is real1_FR?
Darius?
Darius Ford,
Yes.
your friend who was murdered.
Yes.
And does real1_FR say, I know what I'll pay or do so I can play?
Yes.
All right. And when you're talking about the rent, are you talking about the rent at the web?
Yes.
And do you at one point during this text thread say, y'all know
I can't
paid
remember
last
one
month
time.
by myself. Here goes something right here, slug. I know.
I can't remember one time where he actually punished the prosecution for disobeying his rulings. Not one. At the same time, he yells in front of the jury when he believes that the defense has done something wrong.
What you did. Did you say that in
Hey,
part of
Dave.
the conversation?
Yes.
All right. And were you living at the web? Is that where you were living, or were you living with your grandmother?
I live with my grandmother.
All right. But you were paying the rent at the web
Yes.
along with other people?
Yeah.
Other YSL members?
Yes.
All right. Do you recall saying in the same text thread, or rather in the same text thread, I've been paid the rent? Do you remember saying that, or do you need to see it?
Let me see.
This has been rehashed so many times, but let's question him about it once more.
Yeah.
All right. And Slime Life Shawty, who is that?
One is.
Winnie Lee?
Yeah.
And he also is a member of YSL or Young Slime Life?
Yes.
And did Winnie Lee in response ask, how many niggas he sleeping there? You want to see it?
I mean,
Sure. I'll just sit right here.
yes.
And did he ask you to give a number?
Yes.
4K Tay having his way. Who is that?
I don't know their real name.
All right. Did he respond, it's an easy $100 a piece?
Yes.
And was that in response to your saying you needed $1,500 for the rent?
I said it many times. I hope at the end of this trial,
I don't know.
the jury will take
I don't know what
45
she's
minutes
No problem.
and come back with a not guilty
Did-
verdict.
You didn't say, ain't nobody
That's my
working.
hope for it.
Everybody got their own motion. Find your purpose to the game.
Yes.
Did real one
Just as a
for
slap
real
in the face of
underscore FR say
this
6 niggas
horrible
here?
prosecution.
Yes.
Was he talking about at the web?
Yes.
And does 4K say having his way say then, that's 600 right there.
Yes.
And 12 if y'all go 200.
Yes.
Did you then respond? The game, Shawty, you know how it be.
Let me take up you got. No.
Or did real one underscore for real say the game, Shawty, you know how it be?
Yes.
Okay. And did 4K Tay having his way say 40 a day, 1,200 a month?
Yes.
All right.
Oh, this is from today. So this is recap. I'm speeding forward and jumping over all
After
the
that conversation, and
jumping over all the pauses and the sideboards and everything. And if I do that, this might be an hour and a half of stream.
if you need to go ahead and read through it, you can. Because I'm going from page 1703 to 1704
Jesus.
to 1705.
Ask the court, okay, this announces the page, but also the time.
What happened? That
Your
wasn't
Honor,
me
Mr. Steele can-
with the sound.
I'm just reading from defense exhibit number 4.
Just announce the time, please, madam. It'll help everybody kind of orient as the time. is.
Okay, Dave.
Okay,
Yes, Your
all
Honor.
right, thank you.
On page 1706, after that conversation and as part of that conversation about the rent, you see on 1703,
Mhm.
where you say on February the 6th, 2021, according to this document, I've been paying the rent.
Mhm.
And then on page 1706, at February the 7th, 2021, on this document at 1 o'clock in the morning, You have Thugger 1 saying, y'all just start bringing me the money, really?
Yes.
And the Slime Life Shorty, do you ask, the Slime Life Shorty say gonna be no more company at the Yo after that request?
Yes.
And does Thugger 1 say, y'all heard me clearly, sir?
Yes.
And then does he say, man, y'all little niggas stop playing with me?
Yes.
And did 4K Tay having his way say, that's all I be saying, Slime?
Yes.
In response to Thugger 1 saying, man, y'all little niggas stop playing with me?
Yes.
And does 4K Tay having his way then say, I don't care who mad at me?
Yes.
Does Thugger 1 then say, I step FR, meaning for real, for real?
Yes.
Okay. Does 4K Tay having his way then say, they know?
Yes.
And do you respond, I don't get mad, 4K, I get money?
Yes.
Does the conversation...
I know, and the prosecution has done this several times, taking things out of context that is slang words or something, and then make a huge deal out of it. Then the defense comes in and through the rule of completion, this is a part of a longer. It doesn't mean what the prosecution claims it means. Great success. Is this fellow on the stand sleep deprived? For real, for real. This Mr. Stevens, as far as I know, is working night shift at his job. Comes home at 6 o'clock in the morning, showers, gets a nap, gets to court. Then he's in court. And this is the seventh day. He's, or eighth, something of the sort, that he is doing this. He lost his job from the trial. I'm not surprised. And it's so unnecessary. The entirety of his testimony could have been done in a day. But the prosecution rehashing everything. But at least prior to this, as far as I know, he worked night shift, came home 6 a.m., shower, nap, ate, went to court, spent the whole day in court, and then directly after court, went back to work.
Proceed from that point, I don't get mad, 4K, I get money. 3 lines or 4 lines or more down to where Thugger 1 on February the 7th, 2021 at 1:07:38 UTC on this document say, y'all niggas stop saying sucker shit then. I hear all of it. And today I just want to let y'all know. Does he say that?
Yeah.
In response, do you say, I asked about the rent money. That's some sucker stuff. Won't ask about it no more.
Yeah.
And do you say that after Thugger 1 says, y'all niggas stop saying sucker shit then? I hear all of it. And today, I just want to let y'all know.
Yeah.
All right. And after you say, I asked about the rent money, that's some sucker stuff, won't ask about it no more. Does Thugger 1 say, everybody in this text, because everybody, y'all done got something from me. All that little lame ass shit niggas be saying can go far. Does he say that?
Yeah.
YouTube, this is not me saying this. This is me streaming from a trial.
And then does Thugger 1 tell you, slug, relax. It's not about no fucking rent money.
Yes.
And does Slime Life Shorty respond that part?
Yeah.
Does Thugger 1 respond on February the 7th, 2021,
According to the Georgia RICO Act, showing that these are participating in a criminal enterprise, if spoken or unspoken, is enough to bring charges, according to the Georgia RICO. Oh yeah, that, yeah. When they went to arrest him, that job he lost. And then he was in jail for 7 or 8 months, and then he was released. And then he got a new job awaiting this trial, if I remember correctly.
This document 10944 UTC, niggas just be saying little lame shit behind the nigga back and begging when we meet.
Yeah.
Do you respond, speak highly of you in any circumstance, any situation on February the 7th, 2021?
Yeah.
And then does Thugger 1 respond, right? So what are you talking about then?
Yes.
Do you then say understood?
Yeah.
Does 4K Tay having his way say got your back, behind your back, and niggas say I'm sick riding, so be it?
Yeah.
And does Thugger
Action.
Okay, that went on for a good while, back and forth on those messages. So I'm skipping ahead here again.
She explained to you the various constitutional rights you give up by pleading guilty to your satisfaction.
Yeah, and then they played the video from the plea hearing, which again, in my opinion, is unnecessary, because they have the plea agreement, they have the testimony. So this is just embellishing prior testimony, in my opinion, but the judge allows it.
I am holding indictment. This indictment fully.
Yes.
Yes?
Yeah.
Do you need more time to discuss it with her?
No.
Okay. But before you signed it, you had an opportunity to talk with her.
Yeah.
And you don't want to talk with her about the indictment anymore?
No.
Okay, all right. I'll know the indictment's been signed and the plea has been entered.
We are stopping at 24 minutes and 17 seconds.
So noted.
Thank you, Mr. Stevens. I thought that.
Yeah.
All right, any redirect? Mr. Sharp? Or recross, I'm sorry. Go ahead, sir.
Mr. Stevens, good morning again. I'm going to ask you a little bit about the agreement, the plea agreement that you had with the state. Would it help you if you had that agreement in front of you?
And now Mr. Shard is recrossing on this very subject about the plea agreement. He asks Mr. Stevens, how long were you in jail? What happened when did you sign this plea agreement? And as it seemed, as we found out, he did that he signed the agreement just before the hearing. Oh, Teresa Nix. Teresa tries flaws. Sorry. Can you explain how state continues to be allowed to read bits and pieces, combine different text conversation, and this not fly in the face of completion of evidence, etc.? Because the judge allows it. And then that forces the defense to argue the rule of completion to get the full context. So this is totally up to the judge's discretion. Thank you for your question.
Yeah.
Yeah, and here it is about his experience in jail, when did he sign the actual agreement, etc., etc. And this, I think Mr. Shaw did a good job here showing the amount of pressure that was on Mr. Stevens to sign it. Because, as we found out last week, he was put in jail because the prosecution argued that he was a flight risk. So he was remained in jail for all that time. And in my opinion, that has been the strategy all along from the prosecution, to keep all these defendants in jail in hopes to get plea agreements out of them. So let's move on to after the morning break.
Stevens just read, if he sanitizes it, as we did for the plea agreement, take out NPR, take out everything else, and just plays if it's a video of his client, I don't have a problem with that, but we haven't seen it, number one. And
Then why don't we do like we did customarily like last week? You show it to you and then I can make some determinations.
thank you. Mr. Steele, would you send that to us, please, some way or another?
Like, no, come on in.
Okay, what they will argue later on during the day is Miss Love is reading what she claims are Mr. Young Thug's song lyrics. And the defense wants to play the actual lyrics. And that will be interesting later.
Mr. Sharp, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Stevens, we're almost done. Respectfully, Mr. Stevens, you do not wish to go back to jail, do you?
No.
Okay. And you know that there's nothing defense attorneys can file to send you back to jail.
Objection,
Come on.
Your
I
Honor.
sustain the objection.
Hit the thumbs up.
You are aware that the state can move to have your probation revoked.
I sustain the objection.
Yeah. And this continues for a good while. Mr. Shard wants to ask the questions about what would happen if the state decides you didn't follow the plea agreement. And I think it must have been 20, 30, 40 objections that was sustained for the prosecution in this. And then it was a new break. And so more or less what happened was the judge allowed the prosecution to, between the lines, threaten Mr. Stevens with the plea agreement, but the defense could not get their point of view in about the plea agreement. But Mr. Shard got the questions out there for the jury to listen to. And sometimes that's more important than the actual answer. And the camera crew forgot to get the sound up here. Oh, I can't show that. This was during the hearing where they played, this is outside of the jury, where they played the actual song lyrics, which the defense stated that Miss Love misrepresented to the jury. And I can't show anything about it.
The witness or the state read lines wrong. The state has no objection to the official audio for the song being played for the jury, but not an NPR concert version where, you know, Mr. Williams can ad lib, Mr. Williams can say, leave out things. And we would object to the NPR logo being shown, all of that. So if the defendant is going to play his video when the jury actually comes back, we ask that the official released audio of the video be played, or if there is an official video, as some artists sometimes make, that was released, we would ask that that be played instead, and not an NPR tiny desk kind of, I don't know, mellowed out version, I suppose. Because it is,
Thank you so much, Dimitri, for your $2 super sticker. It's a balloon with number one. It's two balloons and with the number one in between. Thank you so much. Much appreciated. It is memberships and super chats that keeps this channel afloat. Thank you so much. Yeah. When was it? Just around Christmas, I did a live reading of the lyrics with alternative music to it, and so far that hasn't been copyright struck. But that was a wild ride. I might do it again at some point.
For all of the reasons. One, I believe that playing or putting in front of the jury something with the NPR logo it may not be intentional, but it could convey to an audience that is listening or viewing that because NPR let him play it, it's okay, as opposed to, and the version that they're playing could be perceived by the jury as the actual released version of the video. And it's not. It's the official audio. I can play that for the court so that the court can understand where our objection is coming from, considering the reasons being offered.
Yeah, I find it hypocritical that they object to the defense playing Mr. Young Thug performing that very song when themselves are cherry picking so much from different chats, from different tweets, from different whatevers. But here all of a sudden, oh, it's very important. Now it's very, very important, this one. Yeah, this particular one.
By Mr. Steele for wanting to play it.
All right, Mr. Steele.
Would the court like for us to play the official audio?
Yeah, let me hear the other one first, and then I'll address.
Mr. Kearns.
You'll need to also mark it as an exhibit, the next state's exhibit for identification.
Yeah, and I have to skip that part.
Completeness and the official audio would be the. Let me see if I understand your objection. Is your objection based on the rule of completeness and the official audio would be the complete version of the song?
In part, yes, certainly. And
That's all right. Is there another basis for your objection?
oh, okay. So the other part that we objected to, of course, was the NPR, that tagging, and there's no need to have this setting and Mr. Williams.
Again, regarding the rule of completion here, the judge allowed the prosecution to not only read verbatim from the plea agreement, he also allowed them to play video from the actual plea hearing. But here, the prosecution argues the rules doesn't apply to the defense.
Doing a Tiny Desk concert when.
I understand.
Yes.
Okay.
So I will just wait for the court to address
Steele?
that one. Is he coming up? And after he addresses that, I'll address that.
Oh, and by the way, the court should have been in session 9:30 today. They were in session 10:15, I believe. So, judge was late today again. And from the information I get, everybody is sitting in the courtroom at 9:30 waiting for the judge.
Ms. Hilton, you'll need to provide the court a copy of what you played from William Mr. from YouTube.
Yes, sir.
Okay, so what's the next state's exhibit?
40 uniform.
40 uniform for identification? All right.
Yes.
Just want to make sure it's captured for the record.
Thank you, Judge.
All right, hold on. Okay, Mr. Steele?
Your Honor, in October of last year, so it's 2023, I served upon the state the Tiny Desk, NPR Tiny Desk version of this song. So I was wrong when I said, I gave it to him at a break, and I apologized to the court. And the state, by saying that they didn't ever get it before, it's the same exact situation you don't want me to talk about, but that's not accurate. Again, number two, they're the same words. There are no words omitted. Number three, there's no official release. In fact, the Tiny Desk,
The YouTube
Is-
the 40 uniforms they played says it's the official song.
yeah, by whom? And the Tiny Desk is July 27th, 2021. And the version that the state just played, States 40, is October 15th, 2021. So
How do I know this is the official version of it?
It's on his page, the defendant Williams page.
Your Honor, this is my time. I have been on cross-examination, and I'd like to play this. And then if the state wants,
Okay, but their objection is to the completeness and I guess the accuracy of this particular video, which would be Defendant Williams 38.
the only thing that is not complete is when Miss Love read certain logos and lyrics. I am playing the complete song. What Mr. Williams said on NPR is Tiny Desk, which is Mr. Williams number 38, is going to be identical to the lyrics in October 15th, 2021. So I, at some point, get to choose how to do the case, and it's more.
I don't think it's a question of just you choosing the case. You're right. You do get to present whatever case that you, from what position you're presenting it from. But
Remember here, the prosecution's version are from a later date than the evidence that the defense wants to put forward. And yet, she claims that is the official version.
I mean, that's the state's objection. So,
And I listened to a lot of the state's objections, and I disagree with the objection. I asked the court that I did not open them. I was going to play it anyway in my case in chief, but the state asked question after question and lyric after lyric, not entirely. And I want to play the whole version, and I should not be handcuffed by the state saying specious things like they're not the identical versions or it's not the official version. I am playing what Jeffrey Williams said out of his own mouth live before this jury. They can see it, and it's more audible. You can hear it better. So that's what I choose to play, and I'd like to play it, and I intend to play it unless, of course, I would obey you always.
all right,
But that's what I'd like to do.
all right, that's the first thing. The second thing is the NPR logo and everything and such as that we that the state's objected to. Can it be removed?
I didn't actually see it, but I don't know. I can't answer that question, but we can see. But I'll identify it as NPR Tiny Desk, and I will play it. I'm not sitting here,
The state's made an objection as to the NPR issue.
I made an objection as to a lot of things.
I know, and I've removed a lot of the things that for the last video that was thought to be played. It had some objections and it needed to be sanitized.
I didn't want any of that except for.
But I do think that sanitized meaning that it has things that are objectionable. So, and I agreed with that. I agree with the state. You should remove those markings if you're going to play that.
I will orient the witness though, and then I will have to ask Mr. Kokum. He gave me a thumbs up, so I assume that means yes, but I don't know. But I assume that means it can be done. I don't personally know.
All right.
That's what Mr. Kokum wants.
Ms. Love, I'm going to overrule your objection I'm going to let him play it.
And Your Honor, understood and understand the court's ruling regarding that. Just as a matter of course, I would ask that Mr. Steele not be allowed to tell the jury or orient the witness by saying that it's an NPR Tiny Desk video.
I would agree with that, Mr. Steele.
And that,
Sure. Over your objection. Over your objection. Yes, sir.
and
Hey, good.
The jury that he performed it on Tiny Desk, and that's where it's from. So I respectfully ask you not to limit it. The state of Georgia
Your Honor,
put in so much character evidence over my objection. Now they're saying we don't want NPR because it's somehow, I don't really know how. I don't really know what's wrong with NPR or what's positive with it.
Demetri says, in saying that the judge is against this is anyway. Her reading the words in that voice is as opposed to the actual song. It's like, why would you not want people to have context? I agree, because when she reads it, and this is something in other trials, when somebody is reading from a transcript that is supposed to be song lyrical stuff like that, that should be a neutral part reading it in a neutral voice. Not the prosecution who is alleging something. And even better, if they have Mr. Young Thug performing that song, then play it. They are arguing about Mr. Steele wants to show the jury an actual video of Mr. Young Thug performing the song that Miss Love, the prosecutor, read from in her own voice, which the defense claim she is misrepresenting in form of words and tone.
I don't think it's it's just it's kind of like the proponency of the video that you showed that was objected to, Law and Crime. Okay. I mean, and the state's objected to that particular issue. So, I mean, I should probably remove that as well. So I don't think that's beyond the realm of acceptable things to consider, because remember, the issue is the song itself. It's not the carrier. So if you could just go ahead and remove that. Mr. Kokomo says he can do it. We'll get it done during the break.
And Your Honor, one more thing.
Just one thing about the law and crime. The reason I was offended by that, and when I say offended me, and not your ruling or anything, because it says law, which some people would think like that's a good thing to have laws, and crime, and that's a bad thing. And we're charged with crimes. That's why I wanted that gone. It wasn't like, law and the justice system. I wouldn't have had a problem, or just legal trials. I wouldn't have had a problem with that. NPR is not prejudicial to anybody.
You made your point, sir. Over your objection. Please remove it. Okay, so we're going to go ahead and do that over lunch.
And so, Your Honor, the other issue with that video snippet, Tiny Desk generally plays snippets of songs because it's a 30-minute segment where they play many different songs. The version that Mr. Steele is asking the court to play, I'm assuming for the rule of completeness, is not the complete version. The version that is the complete version is the version that...
The rule of completeness does not say you have to play the entirety. It means that you have to put things in context. And what the defense have argued is that how you worded it and your tone was misrepresenting what was actually said in that portion you quoted. That is why they want to play that.
It is on the defendant, Jeffrey Williams's YouTube site, where he says this is by, and Ms. Hilton will share it with the court as I'm speaking. It is the version that he released himself on his site. So we're asking that since it is for the purpose of playing the actual lyrics that are being spoken by Mr. Williams for the jury in their entirety, that Mr. Steele not be allowed to cut out portions when that is the sole reason he wants to play it, and that he be required to play not this different version than what he has actually released. So, and the court can see Young Stoner Life records exclusively distributed by the entity after that, and hashtag Young Thug, hashtag Dropping Jewels, hashtag Punk, and so forth and so on. This is from the defendant's own website. And when he is offering it up for the reasons he is at least represented to this honorable court, we would ask that he not be allowed to confuse the issue and not play what is actually the official audio that the defendant himself released to the rest of the world, as opposed to the, video.
All right.
Thank you.
It seems like there's maybe I need to get granularity on this. Might not be something I play right now. That'd be played right now because both of you have thrown around the word official, and I don't know what official is. And unless you all can agree upon it, because the reason I say this, counsels, is that it affects the rule of completeness. So there's either got to be an official release, which has all the song, and not just a remake of the song or a riffing of the song or whatever. But if that's the purpose of playing that particular song, then we need to have the correct version, because there may be different versions out there, all of them claiming to be.
Then why did you allow the prosecution to quote words if you now are
an original release? And I mean, and I'm okay, and I understand that artists release whatever versions for whatever medium or circumstances that they choose to do so, and that's their purview. But for this particular evidentiary issue, it would have to be something that both sides can agree upon, or somebody's going to have to come in here and tell me this is what happens when that the official song is this.
Your Honor.
This is the Recording Academy, is whatever, I don't know. But
Your Honor, you are being, and I'm not saying it's intentional, you are being misled across the aisle from where I sit. The words are identical. You keep being told something that's not accurate. So I will be playing like you ordered, unless you changed your order. I will be playing.
I haven't ordered. I haven't ruled yet.
You overruled the state's objection, and you said that I could play what I want to play. And then Ms. Love just.
But they're telling me that that's not the original version. The Tiny Desk. The Tiny Desk.
Ask the question. What is omitted? The answer will be nothing.
Has anything omitted, Ms. Love? Is there anything omitted from the Tiny Desk version versus the YouTube version?
Your Honor, if the court looks at the time alone, the court can see that. But the point that we're making is that ask that the court listen to both of them, and then
And I can't really, and I'll be honest with you, I can't really tell other than,
then the court allow us a real lunch break to compare the two.
Sure.
There's an official version,
absolutely.
and so we will do that, and we will bring that back before the lunch break ends.
Okay.
And when the court tells me that the time is appropriate, I would like to address the second exhibit that Mr. Steele.
What's the second exhibit now, Mr. Steele? Is there something else you were gonna?
He has said, Mr. Steele has indicated that he seeks to introduce his client's words, and that is absolutely.
Yeah, and they keep going, and they keep going, and they keep going, and they keep going, and then it's lunch. So let's skip to after lunch.
Okay, starting with everybody here.
Looks like everybody's present accounted for, Judge.
Okay, when we recessed councils, we were talking about defendant Williams 38 and states 40. So we proposed or got into a resolution of that.
So, Your Honor, Mr. Brown is going to go and look at what they have put together, Your Honor, on conferring further with counsel for the state, Mr. Carlson in particular, with respect to 28, was it?
38.
30, thank you, Judge. The video itself, Your Honor, is inadmissible hearsay under 24-801A through C and 24-802 and Rule 613. Per 24-801, the exhibit does not have to be self-serving as it did under the old Georgia law, only self-quoted. That is what makes it hearsay under 24-801A through C. And it is there.
What she's arguing here is hearsay. She read the words from the song in her voice and everything. And now she claims that this piece of evidence that the defense wants to show is hearsay under rules whatever's.
Or inadmissible under 24-802. To properly have the video admitted, the defendant bears the burden of providing to the court an exception or an exemption to the hearsay rule, and the defendant has not met that burden because there is no exemption or exception that applies. The video is not a prior consistent.
Yeah, seriously, there's about 130 of you here and only 50 likes. Folks, you know YouTube's thingy. The more likes on the stream, the more it gets promoted, and the more my channel gets promoted, and it costs you nothing. It's so easy. So please do me that favor and put the thumbs up under this stream. Thank you.
Statement under Rule 613 because the defendant has not testified. Therefore, the statement is banned as bolstering before impeachment under Rule 613. Your Honor, with respect to the video itself, the state has left the jury with no misrepresentation or false portrayal about what the lyrics of the song are. And so the rule of completeness and doctrine of curative admissibility does not apply. The meaning of the lyrics is a jury issue that the defendant cannot prove by circumventing the hearsay rule with a self-quoting video. Even for the sake of argument, if the state has in some way misrepresented to the jury what the lyrics are, the state did not introduce a video. So a video is not admissible under either of these doctrines. The only thing then that would be even conceivably admissible would be the specific additional lyrics that provide a different context than the ones the state introduced from that particular song with this witness. Lastly, Your Honor, introducing the video is barred by Rule 403 in that it would confuse the issues for the jury. Because while we here now are focused on lyrics, suddenly the defendant would be introducing a video. That comes in and that is confusing the issues as to what they really are. And so our position is that it is barred by Rule 403 under confusion of the issues, Your Honor. So when the court asked the state to look for lyrics that were different between the two versions, it is actually the defendant, if that is his grounds for having to admit the inadmissible hearsay video, the defendant bears the burden of presenting to the court what misrepresentation the state has made, and then he is limited to playing only the portion of the song that would then give proper context to whatever misrepresentation regarding the lyrics. that currently exists as the state presented in that particular song. I would also point out that it was the defendant who asked and brought up on cross-examination. We're not even talking about open, but on cross-examination, the defendant specifically asked Mr. Stevens, does thug stand for truly humble under God, Your Honor? And that is the only reason the state went back and said, if this is what his name stands for, and he sings about everything else, how many songs has he written that talk about being truly humble under God? So in the 8th edition of Carson on Evidence, Your Honor, page 269, page 80, page 51, and page 432, page 336, and page 438, all pertain to the inadmissibility of this type of evidence and the video in particular. And the defendant simply is not permitted to make a circumvention of the rule excluding hearsay. He has not provided an exemption or an exception. And I think that I see the court has a version of Carlson, and if I've given the court information from a edition that
I'm not as rich as you all are, so I don't have the most recent version, but I am familiar with Carlson on Evidence. So I'm good. I'm good on that. But
Thank you.
anything else? Okay. All right, Mr. Steele, anything, sir? In regards to, I guess, it'd be Williams 38 for identification.
I made my record. There are no differences in lyrics. The prosecution introduced lyrics out of context on redirect under the rule of completeness and under truthfulness to this jury. I would like to do what you already ruled and play the song. And I don't even understand how we're at 24-6-613 prior consistent statement. That's not even close. I mean, we're talking about, you're saying, okay, it's snowing, and we're talking about, well, let's go. So since it's snowing, let's get our pails and shovels to dig up the sand. I mean, this is crazy, their argument. So I didn't bring this up.
Okay.
No intention of playing it.
Mr. Steele, I do understand that. I really do. But
It's play the song.
But you can't at this point in time.
Yes, I can. It was brought up with this.
Okay, but you know what? It's still inadmissible at this point. It's not admissible at this point. I would agree with the state under 801 24.
Dun, dun, dun. Miss Love, during lunch, dug up that. And to everybody's absolute lack of surprise, the judge went with it.
That's 801 A through C, 802 and 613.
At some point, the confrontation clause has to speak in this courtroom. The state of Georgia asked and leveled words made by Mr. Williams. I want to put those words in proper.
Okay, but you won't be able to do it through him. It's objectionable.
Right person.
It's objectionable at this point in time. I'm not saying that it's not. I'm not, like I told you before. It's not that it may not be objectionable at this point, but if evidence comes in for different reasons, Mr. Steele, at this point in time, it's just not coming in. I'm not saying that it won't come in at some point in time.
This court is handcuffing the Constitution. Then I move to strike everything said by Mr. Stevens in its entirety because I can't confront him. You have the awesome power to control these proceedings. But the state of Georgia, wide open that door. I didn't mention anything.
Okay, but that does not make the evidence any less inadmissible. It doesn't.
They took words out of context. And I want to put the words in its entirety the way they are. You should be able to let me see the road to do that, Your Honor.
I just can't let you do it right now, Mr. Steele. It's because the state's objected to it, and I agree with them.
You can do it because the state objected to it. And I understand why Mr. Steele is upset. I would be too, because this happens all the time in this trial. All the time.
Under 801 A through C.
Well, they're wrong. Mr. Carlson has no clue what he's talking about. He's wrong. He wasn't here. And just to throw around the name because he wrote a book, this is not applicable, Your Honor. The state of Georgia said this is what Mr. Williams said. I'm saying actually what he said was this, and I'm putting in the completion of the story. You know what this song is about? It's about coming from nothing. It's about telling your kids, not that you're riding around with a body. It's about telling your kids, if you live under the circumstances that a gentleman like Mr. Williams did, you may have to kill somebody because they're going to kill you. It's self-defense. The state of Georgia wrapped all that up in little lyrics and misconstrued what they are. I have every right. I need to put this in. And it's not good enough to say later, Judge, this trial, I have no clue. I've never been in a case like this. This trial may go on till Super Bowl next year. I don't want to do it in 7 months. It is right now, and I should have the authority to do it, Your Honor. You know, I'm doing everything that I know to be upfront. I give everything I don't have to give. I give everybody a heads up, and it gets spun around. I get to play the song I want to play, and I ask you not to keep doing this and listening. Once you rule, it's coming in. Which one? The state was saying before lunch, I'm somehow changing the lyrics. The lyrics don't change. I tell you that. Now it's all of a sudden another reason. Your Honor, you have ruled. I use your ruling. I embrace them, and I am correct. There has to be a point that we have traction here too. It is a two-way street.
But remember, Mr. Steele, I can always, one of the things about being a trial judge is you can reverse your rulings. And also, here's the other thing as well. You all as a group, kind of release or give me snapshots at any given point in time. And I make a ruling on it. Then more comes out. And I sometimes at that point when I get a full picture of everything, because remember, this is part of what challenge I told you about earlier. When it unfolds this way, I don't get to make the.
Yeah, but the only time when you judge, the only time you are applying this is when it benefits the prosecution. That's the problem with your rulings here. The only time when you seem to change your mind is when it benefits the prosecution. I've said this for so long, it's getting ridiculous. The state said in November of 2022 that they were ready for trial. They had 79 witnesses. When the trial started in December of 2023, they had 731 witnesses, and they keep bringing in new witnesses during trial, and they do not get punished for it. But here you are reversing your 1 hour old ruling because it benefits the prosecution. And this is ridiculous. This is not giving both sides a fair chance, in my opinion.
Best ruling I can at the first time. So unfortunately, I'm kind of hamstringed in terms of that, but I do have a mechanism of kind of reconsidering. I want to get it right just like anybody else does.
Your Honor, I learned about it today. Drug Jewels was mentioned on redirect. I brought it to the court's attention and the DA's attention before that. Your Honor.
And that's why I'm not fussing at anybody about it. I'm not, Mr. Steele.
I need to put it into perspective.
Not now.
Oh, Judge, please take a break and reconsider, because this is important.
Everything's important, Mr. Steele. Everything.
But good. Then I need to put it in. You told me over and over again, there's a battle of the times. You could cross-examine. Well, I'm here.
Okay, you're doing your job.
I want to do this. Every time the state wants to put in something like that last video of Mr. Stevens, I strenuously object. You overrule it and you say you can deal with it on cross. Well, the state's the one who opened the door. I get to go into this. They just mentioned a song and lyrics from the song. They knew what they were doing today. They brought lyrics with them. It was mentioned before Mr. Stevens ever came. They didn't ask you, hey, I'm going to mention lyrics. They just do it. I get to respond. Your Honor, this is critical to me. They are trying to paint Mr. Williams as a person he is not. This is a good man. And I get to show the truth about that song. I didn't introduce the song. I gave it in discovery because I will introduce it later. But now it's right. And if you don't let me do it, jurors form opinions. I know you're instructed, but they form opinions. That's why we confront witnesses immediately. It is wrong to exclude it at this time. It was wrong to exclude, respectfully, lifestyle. They put in the rich gang shirts. I want to show what lifestyle is. You told me do it with another witness. Your Honor, this is the witness. I need to do this. This is the only way.
The other thing, look, you have the right to present whatever it is that you feel you must on Mr. Williams' behalf, as each advocate does here. But there is a certain order, as you all know, that the evidence code requires certain pieces of evidence to be admitted. So the subject, or unless they're by agreement, if there's an objection, then I have to rule on it.
Judge, this was the state's doing. They used part of a song. How is it just?
Question again from Teresa Trice. At some point, can you explain how/why Judge refused to sign the review, which resulted in Mr. Steele appeal to have case dismissed? Oh, I read about that a week ago. So I don't remember the exact terms regarding it, but why the judge refused it, he has discretion to do it. Now, Mr. Steele, as I have appealed that too. And I can't answer why the judge makes his ruling the way it is, other than if it benefits the prosecution, that's his rulings. That's what it seems.
You're a great man. How is it just that the state got to put in with their own inflection of voice on lyrics and say, is this what the song says? And Mr. Stevens say, yes, it does. Next lyric, is this what the song says? Yes, it is. The next lyric, is this what the song said with the expression? I'm not going to say it, but the emphasis on the word F. You blank K. And then I sit here mute. That's just, they did this. And I get to put it in perspective.
Okay, but
I need to do it now. And it's right now because it's a rule of completeness. The witness knows the song. He knew it from his memory. Miss Love was saying, you know the song, here's the song. Here are the lyrics. I want to put in the actual song. The way I want to put it in the video, and then we're done. But Judge, to exclude it, it makes it look like I'm conceding it, and I'm not. And I would not. And to hide behind a hearsay statement, you open the door on that specific statement. I was thinking about this over lunch. What if the police officer, for example, said, yes, Mr. Williams gave a statement to me, and he admitted being there at the time of the incident. And then the state sits down. And then I want to get up and I want to say, I wanted the whole statement in. Mr. Williams admitted that he was there at the time of the statement to help the victim. How is that not the same here? The state is saying, Mr. Williams said this, 1, 2, 3, I think it was 4 different lyrics. Why can't I say, but Mr. Williams put in context, and that is what the song's about. The state cannot now tell the court, let's keep it away. It is wrong. Your Honor, I'm not begging. I am respectfully requesting the Honorable Court to do what you already ruled, and you do have all the information. It was the state's doing. It's not like I'm just standing up and saying, I want to play every one of Mr. Williams' songs. I picked this song because the state picked the song. I picked the words because the state picked only a portion of the words. And I picked the Tiny Desk because it's clarity. It's easy to hear the words.
I agree.
Lyrics. That is all admissible. If the state wants to play the other rendition, I don't care. Play it all day long. But it's not for the state to tell me what I can and cannot do on admissible evidence. And I ask the court to please permit me to try this case so the man has an opportunity to get the truth out. It has been maligned.
all right, sir, thank you. I'm going to be in recess.
Yeah, let's skip ahead a bit because the judge took a break.
All right, can we call for our jurors at this point? Let's get a call for Mr. Stevens.
Yeah, and as you can guess, the judge stood by his reversal of ruling, so not allowed. And it happens over and over and over and over again. If it benefits the prosecution and they can have a slimmer of argument, he rules for the prosecution. It is infuriating for me. And for you who don't know, there's almost 200 of you here. Hi, I'm Nick. I'm a union rep. I do labor law. I have a law degree. I deal with evidence on a daily basis. I don't do trials, but I do negotiations and mitigations and everything in between. This is infuriating to me to watch this, and the way that this judge, in my opinion, unlevels the playing field for the sake of the prosecution.
Please.
Yeah, and Mr. Stevens is back on the stand.
Mr. Stevens. Mr. Steele? Go ahead, sir.
Good afternoon, sir. Mr. Stevens, do you remember today the prosecutor was asking you questions about a song called Dropping Jewels?
Yes.
And do you remember her with her inflection of voice? What that means is her tone of voice, the way she was speaking, giving you certain lyrics allegedly from that song. Do you remember that? It's not. It was one question.
Just rephrase it, Mr. Steele.
Do you remember? Okay. No problem. Do you remember the prosecutor asking you questions about certain lyrics from that song?
Yes.
And do you remember they were a series of questions? I don't know how many, but 3, 4, 5, 6, something like that. Do you remember that?
Yes.
And do you remember her voice stressing certain words?
Yes.
And do you remember, like, and I'm not going to say it, but, you know, for example, when the Honorable District Attorney Love stated the word begins with an F and
Every time a lawyer says the honorable, that is a lawyer speak for no, she's not.
blank CK. Remember how she raised her voice for that? You remember that?
Yes.
Okay. Now, you clearly know the song Dropping Jewels, right?
Yes.
And you've heard that song multiple times, right?
Yes.
And it was written by Jeffrey and a man named Chandler Durham. Remember, let me ask you a question. Do you remember the prosecutor asked you do you know Chandler Durham?
Yes.
Okay. Do you know a gentleman named Turbo?
Yes.
Okay. And Mr. Williams or Jeffrey wrote a song with him. Do you know that? If you don't know, just say I don't know.
I didn't know that.
Okay. Now, Dropping Jewels, the name of the song. Tell ladies and gentlemen, jury, what does the expression dropping jewels mean?
Objection, speculation,
That's-
as it relates to the defense song.
I'll stand the objection. If you can lay a foundation, sir.
Have you heard the expression dropping jewels before?
Yes.
Do you know what it means?
Yes.
Can you please tell the ladies and gentlemen, jury, what the phrase dropping jewels mean? They may not know.
Objection, if it does not apply to the defendant's song, it has no relevance.
It was-
If it does apply to the defendant's song.
Okay, okay, all right, let me rule on the objection. I'm gonna overrule the objection. If you can answer, do you know what dropping jewels means?
Yeah.
All right.
Like teaching somebody like wisdom or knowledge.
Okay. Just because I couldn't hear you, can you just repeat that to the jurors if you don't mind?
Teaching someone like wisdom or knowledge.
And in those lyrics that you were asked about, we're going to go through a few of them, or all of them if we can. You were asked about a lyric, something to the effect of, and I'm not saying the prosecutor said it correctly, but something effective. I told my son if he wanted to live, he might catch a body. Do you remember that as a lyric in the song that you were asked about?
Basis.
As to mischaracterization of what I said, and mischaracterization as to the lyric itself.
All right, I'm overrule the objection.
Do you remember that?
Yes.
Is that a lyric in the song?
Pay attention now, because the prosecution does not want anything said about these lyrics that they didn't indicate. They want their version, their wording, their pronunciation, their emphasis, and that alone.
Yes.
Okay. And from where Jeffrey came from, was there times that people had to defend themselves?
Objection, Your Honor, speculation.
I stand the objection.
Where you came from, were there times that people had to
Okay. You're going to be saying he will get out on appeal once he's found guilty. Here's the thing. Appeal offer loses. Few cases win on appeal. Extremely few cases win on appeal. I've been talking with Florida-based lawyer Steve Gosney about this, and according to him, we are talking about maybe a fraction of a percent that actually wins on appeal. So you always want to win at trial.
Defend themselves.
Objection, speculation.
And
Well, I sustain this irrelevance.
If somebody wants to live and they catch a body, well, what does catch a body potentially mean? I know it can have a different version, but what does potentially catch a body mean? Tell the jurors.
To like kill someone?
Okay. So if somebody wants to live and they have to kill somebody, you ever hear self-defense?
Objection, Your Honor.
I sustain the question.
Do you know what that lyric means to
Objection,
you?
Your Honor. Speculation.
I'm asking about
I think
Mr. Stevens.
I think he's answered that question. Can we move on to something else?
With regards to, you were asked about, I just hopped up out that ghost. I've been driving a dead body. Is that a lyric in the song?
Yes.
Okay. Tell the ladies and gentlemen, jury, what a ghost is.
Objection, speculation.
If you know.
I sustain the question. You didn't rephrase her.
If you know, is a ghost a Rolls Royce
Objection,
vehicle?
Your Honor. Speculation as to what ghost means in this song.
I asked.
Well, let's just. I didn't have to ask him the question.
Does Rolls Royce make? Do you know what a Rolls Royce is?
Yes.
Is it a vehicle?
Yes.
Does Rolls Royce make a vehicle known as a ghost?
Yes.
And if you're driving a ghost, are you driving a dead body?
Objection, Your Honor.
That's basis.
Speculation.
I sustain the question to that.
Is a ghost somebody who already died?
Objection, Your Honor. Relevance.
I sustain the question.
Is that the lyric in the song that you asked about? Is that the line?
Clarification.
I'll rule that objection.
Is that the line you were asked about?
Yes.
Okay. Does it have anything to do with killing anybody?
Objection, Your Honor. Speculation.
I sustain the question.
Who is it?
Sorry, muted. Thank you, Unicorn11, for gifting 5 memberships. It went to Culperistic, Red Ruby Does Lease, Robert Harris Jr., Composer C, and AJ Tyler. All right. For you who just became members, you now have access to tons of members-only content. You also, in the community section on my YouTube channel, have the link to my Discord, where you can continue to discuss the cases I'm covering. All right. Thank you so much, Unicorn11. Thank you so much.
You were asked about the line, or is this the line first? I was locked inside the trap, didn't think about it, but I got out of it.
Yes.
Okay. And is that getting out of a neighborhood, a
Objection, Your
bad
Honor.
neighborhood?
Speculation, and I object to any questions regarding what Jeffrey Williams means in these lyrics that the witnesses read.
I sustain the answer to the question posed right now.
From what?
Again, this is infuriating when she objects. Now, sometimes he overrules them, but the man has to be able to cross-examine, because the prosecution brought this in with an underlying meaning about the lyrics to this same witness. But they object to and get sustained when the defense tries with the same witness to get, is this what the prosecution did, is that the correct version to your knowledge?
The prosecutor asked you is, I was locked inside the trap, didn't think about it, but I got out of it. Is that getting out of the neighborhood?
Objection, Your Honor.
That's an answer. I sustain the question.
Do you remember the lyric? I just came up watching my pops gamble my food stamps. Is that a lyric in that song?
Yes.
There's a lyric in the song. Is it bad? You better get rid of it or lose on it. I know you heard that old saying, folks round about bad fruit. Is that the song, the lyric? No, tell the lyric.
You didn't say it right.
Go ahead.
You want me to say it?
Yeah. Tell the jurors.
Start it off. Let me see what part you was on.
Okay. Is it bad? You better get rid of it or lose on it. I know you heard that old saying, folks round about bad fruit.
Oh,
That's fine. Mr. Stevens,
if it's bad, you better get rid of or lose on it.
okay.
I know you heard that old saying about bad fruit, food. One of them, fruit of food.
One bad apple spoils the bunch.
Objection, Your Honor, that Mr.
I'm asking-
Steele is asking what the meaning of the lyric is, because there is no testimony.
So what's your objection, madam?
So objection as to speculation.
I sustain it.
I'm not asking, okay.
I sustain it.
To you, that old saying, what is that old saying? If you know
Objection.
What are we talking about?
that the lyric refers to.
Objection, speculation.
Mr. Steele, I'm standing. Bring him back to what is it you're asking him about in terms of the, because I don't think he's been able to identify anything at this point. So
Dropping jewels, Mr. Stevens, is about teaching.
Objection,
Right.
Your Honor.
You already-
Speculation.
He already said that's what it means,
Your Honor, as to the song.
I'm overrule the objection.
correct?
Yes.
I couldn't hear you.
Yes.
And Mr. Williams talks about his son and daughter in that song, right?
Yes.
And he wants them to know what a struggle it is, right?
Objection, speculation.
I sustain the objection.
That's what the song is about to you,
I sustain the
isn't it?
objection.
Speculation. So objection.
To you. Is that what the song is about?
Objection, Your Honor.
The state asked all about the
No,
song.
hold on. I'm overrule the objection. Let me get the question out first.
To you, the song Dropping Jewels, it is teaching children to go a better way, right? Teaching about the real life, right? Warning them.
To me, he's talking to his kids and he's talking to other people too, teaching, saying the things, the life coping skills. I don't know.
Okay. All right. Now, I want to talk with you about some of the chats that the prosecutor was asking you about, okay?
Yes.
And I just want to start here. Your Honor, with the court's permission, can the Honorable Mr. Como put up Mr. Williams, number 2? It's already in evidence.
Yes, sir.
Your Honor, will the court permit me also to just grab that from the court reporter stand just to follow?
Yes, ma'am.
I'll use it, Mr. Stevens, please.
Okay.
Just give me the page numbers from that exhibit 2 consists of at the very top of the page.
1603,
1603
2 pages.
to 1604.
Okay, JC says as well. It says, I was watching another YouTuber today that is in the courthouse and said the jurors were shaking their heads today during testimony. Yeah, if I was on this jury, I would be furious at the prosecution. Now, we have the advantage to see what's going on when the jury isn't there. But if we remove all that, for me, it would be apparent that the prosecution is actively trying to taint the case, in my opinion.
Is it 165?
Mr. Stevens, if you don't mind, and if you can't see that for whatever reason on your screen, we have it in evidence already. You can look at it, okay? Just let us know. I'd like you to just show,
Your Honor, I'd object as to the state having asked no questions about 1603. We asked about defendant Williams 4, not 2.
And here they are. Again, They object to this. Here's the thing. The prosecution has for days referred to things on that was posted on Instagram. But I guess they don't want this in because it directly goes against their case.
So is this defendant's, which is this? I'm sorry.
Number 2, Your Honor. Mr. Williams, number 2.
In evidence already?
Of course.
Let's see where it's going. I'm over for the time being. So.
Okay, you see at the very top right-hand corner on Mr. Williams, number 2, it says 1603. You see that?
Yes.
Okay, and then the next page, just to give you an idea, and it's the second page of Mr. Williams, number 2. For ladies and gentlemen, jury in this honorable court, you see in the right-hand upper corner, it's in like blue and white, 1604. Do you see that?
Yes.
Where it says Instagram business record?
Yes.
Okay. If you can just remember, if you can, otherwise I'm going to show it to you, no problem. 1603, if you could try to remember that. Now, in 1603, on the page before, Mr. Kokomo, at the bottom, towards the bottom of that page, you see at, let's see. See where it says bully with 2 eyes, 1 at 1:59:09 UTC time on your, like kind of like the top center of your screen. See where it says that Instagram user sent an attachment?
Yes.
And the text says yo at little Uzi Vert. You see that?
Yes.
And that's a gentleman you already explained to, ladies and gentlemen, jury on that date, which is February 4th, 2021, revealed that he had a surgically implanted.
Your Honor, asked and answered on cross, and I didn't even ask about it on redirect.
I'll hold the objection.
And that's the gentleman who you already talked about on that date, revealed that he had a.
Yeah, this goes back from what they have been arguing about. The prosecution argued that certain wordings was about more or less ending somebody. And then the defense showed that no, has nothing to do with that. This is about a gentleman who, for some odd reason, put a diamond or a jewel on his forehead, implanted on his forehead, which directly contradicted what the prosecution tried to tell by cherry-picking certain pieces of Instagram texts in an effort to make the defendants look as bad as possible. And they have objected forever about all of a sudden this rule of completion is also not valid according to them. And you saw it earlier when the prosecution was allowed, even though they had all the plea agreement and talked about it endlessly and read verbatim from it, they still showed the video from the court proceedings or the plea hearing with this judge, and he allowed that. But here, and with the video, the judge rules in favor for the prosecution.
Surgically implanted pink diamond in his forehead. Is that fair to say?
Yes.
Okay. And that gentleman's a performer, right?
Yes.
And then underneath it, it says this real. Is that fair to say?
Yes.
And then the next one is that N Uzi crazy. This is all about his diamond in the forehead, correct?
Yes.
Okay. And then that boy take a punch to the head. It's over. And then on the next page, which is 1604.
Your Honor, I object to the, I don't know if that was the question, but it's testifying. I object to testifying.
I'll sustain this to the form of the question. You can rephrase, sir.
I was just asking Mr. Kokomo to go page 1604. And you see that at the top, they trip it now.
Yeah.
And then he cap. And then Jeffrey, YSL rule the world kid 24M on an N's head. You see that?
Yes.
And then you said came from nothing for something, right?
Yes.
Okay. And then you already said it, but in Mr. Williams, number 3, which was played to the jury, that's what they're talking about, which I'm displaying, Your Honor. Already in evidence. It's a video that the jury saw. That's the photograph of Mr. Little Uzi Vert having the pink diamond in his face, right?
Yes.
All right. Now, I want to show you what already been identified by you.
Your Honor, as to the line of questioning regarding Act 127, not objectors to asking that.
Okay, I'm going to show you, I didn't ask the question, Your Honor. Mr. Williams, number 17, sorry, been displayed to the jurors. I asked to display it again. It's over to Act number 127.
Yes, sir.
Now, I'm going to hold it up. I've been told that jurors can't see it, so I'm not going behind you, okay? Can you see it though, Mr. Stephen?
Yeah.
All right, and you see where it charges in count 1 over at Act 127, February 4th, 2021, that these gentlemen, Mr. Lee, yourself, Mr. Williams, associates of YSL, did engage in conversation with Mr. Williams states.
Your Honor, I object,
YSL.
he has already asked the same exact question on cross-examination.
Let him finish and then I'll make a ruling.
Yes, sir.
YSL ruled the world, K24M, 24M on an N's head. You see all that?
Yes.
And then the next line, it doesn't have any type of
Objection, Your
comma.
Honor, as to the commentary.
I'm on cross.
Is there a question though, Mr. Steele?
Yes.
Okay, all right, what's the question?
I'm getting there right now. And you see how it just continues in the indictment? You all just start bringing me the money?
Yes.
All right. And then, man, you aims, stop playing with me. See all that?
Yes.
All right. Now, you remember that 1603 and 1604 that we discussed already?
Yes.
All right. Now, I want to show you what's already been marked with Mr. Kokomo's permission, Your Honor, and admitted into evidence as Mr. Williams number 4. And you were asked some questions about this exhibit on reader.
Yeah, this is the defense showing that in the actual indictment, they took one quote from there and then one quote from way over here and added them together to give the context that wasn't. And that's the state's case all the time. Taking that and that and that and that, putting it together, even though they may even be unrelated, in order to make the argument these guys are committing a crime as a criminal enterprise. It is infuriating.
Correct examination by the Honorable Miss Love, and I'll show it to you. Okay?
Yes.
Well, with Mr. Kokomo's permission. You can't see it, Mr. Kokomo, if you could bring it down a little bit. Okay, thank you, sir. You see at the top of Mr. Williams number 4, the page 1698
Yes.
in blue?
Yes.
And from number 2 of Mr. Williams, 1603, that's approximately, I heard you say you're not good in math, I understand that. That's approximately 95 pages of text between the two quotes, right?
Yes.
Okay, so this is a totally different day also. If you remember, if you don't remember, we could go back to it. On Mr. Williams number 2, this is on February 4th of 2021, right? Mr. Williams number 2.
Yeah.
I could show it to you. Do you need to see it?
No.
Okay.
That wasn't going over?
It's the same thing. Yes, sir. And then on Mr. Williams number 4, this is now on the very top of it is February 6th, 2021, right?
Yeah.
Okay. And then, as the indictment says, the next line after on Mr. Williams number 7, you'll just start bringing me the money. You see that?
Yeah.
That's not until February 7th, what, about 100 pages later in the text messages, right? Or the chat messages, right?
Yeah.
Let me show it to you. Give me 1 second. I apologize. Tricia, what page?
Now the defense will show that the two quotes the prosecution shows to have in their indictment are
Let me do this.
hours, if not days apart.
On page 1706, if you don't mind, Mr. Kokomo. Right in the center, just below center of that page. Do you see at time 1:00:20? Mr. Kokomo, if you could wrap your, you circle it. Do you see that, Mr. Stevens?
Yes, yes.
Okay, and that's on page 1706. Right? That's more than 100 pages in chat later, right?
No, Big Easy. The DA falsely mixed up text messages to make it different from what was being said, and the judge allowed it. Yeah. The prosecution, any prosecutor, should be going after what's the truth. Instead, they are doing everything in their power to mix up the cards as much as possible, throwing everything on the wall and point at it and tell the jury, look, they are criminals. Believe me, because I'm the prosecutor. That's more or less everything I've heard so far in this trial. And it's infuriating that I can't even understand how this even got to trial. But I also know that the Georgia RICO Act is so broad and so vague that it allows it. And the judge, in my opinion, is helping the prosecution as much as he possibly can. It's infuriating to watch. Infuriating.
Yeah.
Does that have anything to do, that quote right there, you'll start bringing me money? Really, does that have anything to do with what the prosecutors put in Overt Act number 127 earlier about little Uzi Verts?
Yeah, we didn't objection as to the point of the question. We did not have anything about Uzi Verts.
I stand here. There's part that is on the board, on your screen, you'll start bringing the money. If you go down a little more, Mr. Kokomo, on that page, you see right there, man, y'all little hands stop playing. You see that's the second last one?
Yeah.
Do those items, those words have anything to do with little Uzi Verts
Objection, Your Honor, again.
statement? I stand objection. Does it have anything to do with what is written at the beginning? Why so rule the world? Is it anything to do with it?
Them two different conversations.
Right. Objection to the commentary on the right.
I stand it. They're not even close in context. Context is a bad word. They're not even part of the same conversation, right?
No.
And Ms. Love started to read sections skipping around in Mr. Williams' number 4 to you earlier today. You remember that?
Objection as to the compound nature of skipping around.
It's not a compound question.
I stand as the form
Do
question.
you remember the Honorable Ms. Love asking you about Mr. Williams' number 4?
He goes back to the honorable. And we all know what that means. It means the polar opposite. He's more or less saying without saying that Ms. Love is disingenuous.
And ask you about specific chats this morning. If you don't remember
But
that.
she right here reading with me.
Yeah.
Yeah.
You remember that?
Yeah.
And she was going out of sequence, right? With that, do you know what I'm?
Yeah, I know what you mean.
Okay.
I'm trying to remember what she reading like. Some she was reading directly right up on each other, and some she'll flip the page. So yeah.
Okay. Now, the chats that Mr. Williams is referring to that you were a part of in Mr. Williams number 7 and the number 4, and the jurors will have this.
Objection, Your Honor.
It's in
I
evidence.
stand the question.
This is in evidence. Mr. Williams is commenting on the fact that you were trying to raise money for rent, right?
Yeah.
Okay. Where in this chat or in anything in Mr. Williams number 2, is there anything criminal dealing with Mr. Williams?
I stand the question.
Where is there anything that furthers the interest of a RICO conspiracy in
I
Iowa?
stand the question, Mr. Steele. Let's move on.
Now,
Yep. In this case, Mrs. Steele knew it would be objected and sustained. He was not interested in the answer. He was interested in letting the jury know. He only wanted a question out there. He wasn't interested in the answer. Sometimes you have to do that when you know you're getting objected and sustained all the time. That, okay, Then let me put out the words in form of a question. You can't put the toothpaste back into the tube. You can't shovel the crap back into the horse, and you can't unfuck a clusterfuck.
Miss Love only asked you about Mr. Williams number 4, the one we were just talking about. It's on the screen, right?
Yeah.
She didn't mention Mr. Williams number 2 that I just showed you, right? Correct?
I think it was like 21 pages. That was she showed me.
She didn't ask you anything about Mr.
No.
Uzi Vert, correct?
No.
That's Mr. Williams number 2 and 3. She didn't ask you about Mr. Williams number 7 at all, right?
Oh, rule the objection.
Am I correct?
Yes.
She didn't ask you anything about that. Okay. Now,
Kellyanne Van Sudden says, I just tuned in, but been worried for Slug going back to jail. Don't think it's at all fair. I'm worried too, because in my opinion, he has done everything that the plea agreement says. But then the prosecution went to question around the plea agreement that he hasn't. That only says you have to speak the truth about whatever the prosecution will ask you. And he answers as good as he could. But the prosecution doesn't like the answers. And I'm convinced Mr. Stevens is doing his absolute best on the stand to follow the rules of the plea agreement. But I'm very worried that the prosecution will go to the court and ask a judge to have that plea agreement revoked as soon as Mr. Stevens walks out of this courtroom. That's a vindictive prosecution. That's not how a prosecutor should act. The reason you don't like how Mr. Stevens answers is because the plea agreement is a pile of garbage. And you weren't prepared for a good defense. And I think the prosecution will try to punish Mr. Stevens for their own incompetence.
Mr. Love asked you over and over again about Mr. Williams talking about God, being humble, truly humble unto God. You remember any of those type of questions?
Objection, Your Honor, to compound.
I stay in the question. Do you remember questions about that the prosecutor asked you about Mr. Williams being humble?
Yeah.
Do you remember questions that the prosecutor asked you about God? Mr. Williams talking about God.
Yeah.
Do you remember questions that the prosecutor asked you about truly humble unto God? Just truly humble unto God, thug. You remember those questions?
Yeah.
And she limited you to a song that is in existence in the public domain. Do you remember that? She kept asking about songs.
Your Honor, I object as to the characterization.
I stay in the question.
Do you remember the prosecutor consistently saying for you to remember what song mentions humble or God? Do you remember that? Or truly humble unto God? You remember that?
That was my understanding to remember a song that said something like God. To say a song that said something like God. And I choose that one because I remember that specific part in the beginning of the song. Where you were
Now, this truly humble under God, I haven't found the interview and I haven't looked for it, I must say. But I've seen in other YouTubers chat about an interview from somewhere around 2018, 2019, where he explains truly humble under God. I haven't seen it myself. I'm just giving you that information. And I simply don't always have the time for that kind of research because I have a day job. I am the shield for a lot of clients regarding to labor law. A lot of many employers are good, not all of them are. And when employers aren't good to their employees, the employees can refer to me and I will be their shield against an unfair employer. That's what I do on a daily basis. So, and sometimes I have 8-hour workdays, sometimes I have 14-hour workdays. I'm trying as much as I can to get time for the streams of this Young Thug trial. Because I believe that the court and the judge is limiting the defense attorney's abilities to be that shield their defendants deserve, and honestly, have a constitutional right to.
Burn to God.
And you're talking about what's the meaning of life or whatever dropping jewels is?
Yes.
What Ms. Love didn't ask you about is whether Jeffrey ever gave any interviews, public interviews about the meaning of did she?
Trying to get in self-serving.
I'm not asking about a statement.
Let me finish the question before I can rule on it. So what's your question, Mr. Steele?
Did Ms. Love ask you anything about Mr. Williams giving an interview or interviews in 2016, let's say, 8 years ago, about being humble and what it means that he doesn't want to be known as Young Thug? Did she ever ask you those questions?
Objection compound.
I stand as deformed. Why don't you rephrase?
Okay. Did the prosecutor ask you any questions about Mr. Williams' statement, public statements about being humble?
Objection, Your Honor. As to
Basis.
any statements by the defendant would be self-serving, hearsay.
I stand.
I'm not asking a statement. I'm asking what Ms. Love asked that.
I stand the question now. Form of the question.
The judge doesn't want you to say what Mr. Williams said. Don't say what he said. Do you know of public interviews of Mr. Williams given concerning the topic of being humble?
Objection. One,
Basis.
it would be, again, he is attempting to refer to self-serving hearsay. It would be speculation as to what the defendant meant in the interview.
That's a horrible objection. The question is, have you ever... If that is hearsay, then so is Ms. Love's questions about Mr. Young Thug never have called himself truly humble under God, about being humble. It should work both ways, but here we are.
That's the same question. Do you know, without saying what Mr. Williams said, because the judge is sustaining that, do you know Mr. Williams explaining anything in interviews?
Objection, Your Honor. As to anything about.
That's the same question 3 times, Mr. Steele. So do you want something else?
Do you know whether Mr. Williams has ever discussed, don't tell me what he discussed, that he does not want to be known as Young Thug, but it's what makes money?
That's been asked and answered. I'll stand the question.
Okay.
No, it hasn't, because it was objected and sustained all the time. So asked and answered, wrong, in my opinion.
Okay. You know the song Let Me Live by Mr. Williams?
Your Honor, I would object to any reference to statements by the defendant offered by the defendant.
Overrule the objection. Can you answer that, sir?
Trayvon Martin's song?
Objection, Your Honor, as to what song is about.
Yeah.
Do you know that song?
He needs to finish it. First, maybe ask him if he knows the song.
Do you know that song?
I'm trying to think.
Take your time.
No.
If I played you the song in private, do you think that you can tell the court and the jury whether you recognize the song or not?
Yeah.
Here's the thing, and I've been discussing this in other streams. District Attorney Fannie Willis got money from Fulton County and federal additional money to clear the docket of cases that has been there for years due to the CVID thingy. According to a motion put in by one of the by Mr. Roman in another RICO trial, there are currently in Fulton County over 200,000 cases. Most of them haven't even been indicted yet. Around 20,000 cases where there is an indictment. And Fannie Willis got money to clear as many of those cases up as possible. She is using that money, for 4 RICO trials. Now, one has been pled out. Now you have the Young Thug RICO, the Trump RICO, and one cop RICO. And meanwhile, here we are with a trial that takes up its entire court's time for at least 6 months. And this is the level of evidence they are producing in this one trial. This trial alone, at the end of this, will have cost Fulton County taxpayers close to $10 million. Every day, this courtroom could have handled between 4 and 8 cases, misdemeanors, felonies, every day, 4 to 8 cases. But they can't, because Fannie Willis wants to be known as the RICO prosecutor.
Objection on 24-801.
I stand the question.
Do you know whether Jeffrey Williams spends a tremendous amount of time when you're with him, when you speak with him on the phone, in a studio recording?
Yes.
Do you realize that Mr. Williams has thousands of songs that are not released?
Yes.
Do you realize that Mr. Williams has thousands of songs that have been stolen?
Objection speculation.
If you know.
An objection basis before the answers.
I stand as the form. Why don't you rephrase it?
Do you know whether Mr. Williams' art has been pirated or taken? If you know, if you don't know,
An
just say it on
objection
that.
as to relevance as well.
I stand the question.
Point being is Mr. Williams has a lot more songs recorded than what's in the public domain. True?
Yes.
Thousands more, right?
Yeah.
And do you know that Jeffrey Williams has songs under Jeffrey and not Young Thug? Do you realize that?
Yeah.
And do you know that those songs don't sell very well?
Objection speculation.
If you know,
I stand the question.
are you aware of that?
I don't know about the sales for real.
Okay. All right. The prosecutor asked you about Sergio Kitchens. You know who I'm referring to?
Yeah.
Now, he is an world-renowned, if you know, known artist. True?
Yes.
And he goes by the stage name, what?
Gunna.
Gunna.
Yes.
Okay. And the prosecutor asked you whether he was a co-defendant, and a co-defendant means it's a human being. Defendant's just a kind of strips a person, but it means it's charged with a crime, right? It's,
As to
I stand the question.
you understand that it's the state of Georgia plaintiff versus Brian Steele defendant. I'd be the defendant. You understand that? That's where the word comes from? Okay.
Yeah.
And Mr. Kitchens is in this indictment an accused. You aware of that?
Yes.
Okay, a defendant, right?
Yes.
Okay. And Mr. Kitchens, if you're aware, resolved his case. True?
Excuse me. Yes.
About a month before you did, right?
I don't remember. Was it a month?
That's fine. And he was released from jail, right?
Yes.
And he pled Alford, meaning he maintained innocence, right?
My speculation
This
is
is-
relevant.
I stand the
It's
question.
on the indictment.
But I stand the question.
All right. Now, do you know what an Alford plea is?
Objection, Your Honor.
I stand the question.
I'm asking the witness if he knows.
I stand the question.
Okay. All right. Now, I want to
For those who don't know, an Alfred plea is when a defendant remains their innocence, but acknowledges that the evidence against them will probably lead to a guilty verdict, but they remain their innocence despite pleading guilty. That's roughly what that means.
talk with you about Gunna or Mr. Kitchens. The prosecution keeps calling you the leader or the beginner or the creator of YSL, one of them. You realize that?
Yes.
You and Jeffrey and a man named Walter Murphy known as DK, right?
Yeah.
That's what they're saying. And tell the jurors what crime that you know that Sergio Kitchens ever committed to further the interests of the criminal street gang YSL.
I object, and I'd ask. you
Faces.
to vote.
Okay. All right. Come on up.
All right. You know what this means. It is sidebar counter number 63. Yeah. throughout this trial, we're on day 21. There has been 63 sidebars. Maybe you're not an avid trial watcher. Maybe you've seen a couple or a few, or you're completely new. That is an enormous amount of sidebars, even by this complicated trial. That is an average of at least 3 a day. And remove the judge is always late with a half hour to 90 minutes. Every break that is 15 minutes is half an hour. Every lunch that should be an hour is an hour and a half at least. These are just sidebars that has to happen in front of a jury. If you calculate it effectively, we are in actual trial in front of a jury. We have spent maybe 8 days, full days, in front of the jury with 63 sidebars. Let's go.
Mr. Stevens, tell the ladies and gentlemen of the jury, based upon your own personal knowledge, whether Mr. Kitchens or Gunner ever committed a crime to promote YSL.
Objection, Your Honor, compound.
Tell the ladies and gentlemen of the jury whether Mr. Kitchens ever committed a crime to promote the gang YSL.
Your Honor, he asked the exact same question, so it's still a compound question, so my objection. There are 2 questions.
I sustain the question.
What did Mr. I'm sorry.
Go ahead, sir.
What did Mr. Kitchens do, if anything, to benefit a criminal street gang YSL? Tell them.
I object on the grounds that I mentioned at the bench, and I also object on the basis that.
I'll sustain this to the question. Mr. Steele, why don't you ask the
So what happened here is Mr. Steele has the foundation to ask a question related to this, but he must form the question so it's unobjectable. Here's the problem, and we see it all over and over again. The prosecution objects, and the judge sustains by anything he possibly can sustain it with. Even though Mr. Steele is have the foundation for questioning Mr. Stevens regarding this.
one question to begin with, and then based upon that, if he answers anything, then we'll take it from there.
Do you know if Mr. Kitchens committing any crime to benefit your gang?
Objection, Judge.
I'm asking a single
Judge,
question.
he's asking a compound question.
No, he's not. Not in this one. I'm staying the question. I mean, I'll overrule the question. Let him answer that in that last one.
And I'd ask for a basis for his knowledge.
Go ahead, Mr. Steve.
I don't have any knowledge.
All right. Okay.
Now, I want to talk with you about, and if the state can help me, if you are able. I believe that's 20 U.E. Mr. Stevens, it'll come up on the screen when the honorable prosecutor puts it up, and I thank her for doing that very much.
Mr. Carnes, would you let us in?
It should be a mistrial, but I don't think this judge will allow that motion or will sustain that motion. I think the judge is fully prepared to go through this entire trial, hand it to the jury, and then retire, more or less. That's what I think. And because then it's out of his hand. If they acquit them, it's out of his hand. If they convict them, it's out of his hand. then he can just say, well, the jury spoke, let the appellate court take care of it. All while he is making poor judgment calls, in my opinion.
I believe it's 20 or 29, but.
And again, if you don't mind, please hit that thumbs up. It really, really means a lot for my channel that you do. Thank you.
And thank you, Miss. Thank you so much. Mr. Stevens, if I can go through this photograph with you and the letters at the bottom, if that's okay with you, okay?
Yes.
Here's my 2 cents. The reason he's sitting on a chair out, no matter what the text says under it, the reason why a person sits in front of a Rolls Royce on a fold-up chair is because this is a photo op. I would imagine more people have done the same photo op.
Okay. First of all, do you recall where this photograph was taken, best to your memory?
No.
Okay. Is it fair to say, if you remember, this was what's called a pose photograph, meaning you know it's the camera is taking your picture, you're smiling towards the camera. Is that true?
Yes.
Okay. And behind you, it appears to be, I see 3 different vehicles. Is that what you see in the 27 UB?
Yeah.
Okay. And the far vehicle in the top left is a SUV. Is that fair to say?
Yes.
And then there's a vehicle next to that one, correct?
Yes.
And then you are seated in a chair right in front of a blue vehicle, right?
Yes.
Is that a Rolls Royce?
Yes.
And whose Rolls Royce is that?
Mr. Williams?
And did he give that to you?
No.
Okay. Now you are seated, and if you can blow it up if you don't mind when you get a chance, maybe on the neck area of Mr. Stevens. Mr. Stevens, you see the honorable prosecutor blowing this up for you?
Yes.
All right. And I'm focused on, it looks to me like there's 2 chains. Is that fair to say?
Yes.
And one of them is a traditional, very strong, powerful cross. Is that right?
Yes.
Did Mr. Williams give you that cross?
No.
Did Mr. Williams give you the chain that cross is on?
No.
How about the next? You have something that I believe says a name. Is that right?
Yes.
What name is that?
Mine slug?
Okay. And did Mr. Williams give you that jewel?
No.
And did he give you the chain?
No.
Okay. Then if you don't mind, if you can scroll in on the left hand. That's fine. I appreciate it. Do you see what the honorable prosecutor tried to get enlarged as much as possible? Your left wrist?
Yes.
And that is a Rolex watch, correct?
Yes.
And it's worth approximately $5,000?
Yes.
And that was given to you by Mr. Williams
Yes.
as a gift,
A birthday gift?
birthday gift?
Yeah.
Okay. Did you do anything for Mr. Williams to promote some sort of criminal activity in exchange for that birthday gift?
No.
Did Mr. Williams give it to you and then tell you, I'm ordering you to go commit this crime on behalf of YSL? Did that happen?
I sustain the question.
Did Mr. Williams give that to you with any type of strings attached? That may be a bad way to say it.
Objection.
Did you do
I
any,
sustain this the form. Go
did you do anything for Mr. Williams in exchange for that gift?
Gave it to him because I was born on my birthday.
Because of a birthday present.
Right.
All right. Now, if you can go to the right wrist, do you see that I believe you're wearing what I call a chain on that right wrist? Do you see that? And if I'm wrong, just say I'm wrong.
You wrong?
Okay, that's just part of the fabric,
It's not, that's not yours.
not jewelry. Okay, nothing to do with Mr. Williams.
No.
Okay, then if we can go up a little bit, actually down a little bit. And you see that writing?
Yes.
Okay. And this was in the first line that there's words. This was liked by _little git and 1,181 others, right?
Yeah.
And this on Instagram. Is that fair to say?
Yeah.
Okay. And then what you wrote is _1slug, bust down Rolly, came from Thug, meaning Mr. Williams, right?
Yeah.
You know it's real.
Yeah.
Real or real love or whatever little baby said, right?
Yeah.
And what does that mean? Whatever. Well, who is little baby?
Entertainer.
Okay. Is he a musical entertainer?
Yes.
And people would say a rap entertainer, gangster rap.
entertainer. Like,
Okay.
he do a lot of stuff.
And what does it mean? If you remember, what did you mean by whatever Little Baby said?
I think that was one of his lyrics in his song.
Okay, that's a song, right?
Yes.
Okay. Is there anything in State's Exhibit number, and they said 27, you, little B is in Barry or Bravo, anything in there that's connected to somehow a criminal conspiracy RICO count?
Objection, Your Honor. That is a matter of
He's right here. Good question. Did you post this in any way that is criminal activity?
Your Honor, objection. As to the same.
This is his poster.
Jury is.
I'll rule the objection. Can you answer the question?
Is this in any way affiliated with criminal activity?
Your Honor, that objection, because that is a matter of you arguing.
I'll sustain the question.
Is State's Exhibit number 27 UB have anything to do with a crime and Jeffrey Williams?
Mr. Steele, I've sustained the objection. Please don't ask it again, please.
Ta-da! Well, again, this is more. Mr. Steele realizes he's not allowed. The court does not allow Mr. Stevens to answer that question, so he repeats it. This is a tactic. It's repetition. Most lawyers use it when they can, and in this case, he's repeating the question in similar ways. He knows it's going to be the objection is going to be sustained, but he still does it to put the words in the ears of the jury. Because if it is evidence in the trial, it should be evidence of a crime. But what's the crime? The prosecution alleges that this has something to do with crimes being committed to put the YSL gang forward. But then don't they have to prove that those specific things was bought through crime?
Now, the prosecutor asked you today that after Jeffrey became famous, you went separate ways. You remember something like that?
Yeah, she had me a lot of questions. My bad.
Actually, Jeffrey spent a lot of time working, didn't he? Before he became famous.
Yes.
And prosecutor asked you, why didn't you spend that much time? You already explained that to the jury, right? Basis.
Arguing or asking a question she wasn't, I didn't ask that, misrepresenting.
Oh, objection. Can you answer the question?
You didn't.
Yeah, I answered. I told her I didn't have no talent.
And that's very, modest of you. Modest means polite of you to say you didn't have the talent, but you also didn't put in the time with Jeffrey, right?
No, I didn't put in no time.
You were doing other things while he was working, right?
Yes.
That's what you said earlier on your cross-examination, right?
Yeah.
Nothing about when Jeffrey became famous. That's how Jeffrey, he went for something, right?
Yeah.
You told the jury it was amazing. It was your word.
Your Honor, I'm going to object if he's already asked and answered.
I sustain the question.
All right. State's Exhibit number 16U. It might be in front of you. Is that what the number is, if you don't mind helping me out, Mr. Stevens?
Yes.
Now, you were answering all the questions asked by the Honorable District Attorney Hilton. Remember that?
Yeah.
And you were put under oath, right?
Yeah.
And the Honorable Judge Glanville, Chief Judge Glanville, he was here asking you questions as well. He was present, right?
Yes.
Where in that document or in the video does it ever say that Jeffrey Williams was part of a criminal street gang? Tell the jurors.
They don't.
I'm sorry?
They don't.
So you were under oath, having to answer all the questions of the prosecutor, and they didn't ask you that question.
Ain't in there. No.
Isn't that weird? In the entire plea deal, nowhere has Mr. Stevens been asked the question, does Mr. William belong to a criminal street gang? Now, what's also in the plea agreement is that he's not allowed in this plea agreement, which he signed. He is not allowed to testify if the defendants are innocent of the allegations. The prosecution in this plea agreement does not allow Mr. Stevens to testify about the innocence of the defendant. AJ Tyler question: Why they use different lawyers for different witnesses? And if the lead lawyer asks, does that mean the witness is important? There are 6 defendants in this RICO trial. They all are separately indicted and charged. They have their own lawyers with the responsibilities to their client alone. And yes, as AJ points out, this, I believe, is a Supreme Court ruling. Being in a gang isn't illegal. But in the Georgia RICO Act, furthering a criminal gang, and that's the wording of it, being in a gang and being in a criminal gang.
I didn't get asked that.
I can't hear you.
I didn't get asked that question.
Meant for the state side. It's some of the prosecutors are specialized in one area with expert witnesses or cop witnesses or something like that. So they take turns to relieve each other from having too much burden during the case.
Was Jeffrey Williams part of any criminal street gang whatsoever, sir? To your knowledge, as charged in YSL, RICO count, or any other gang activity here?
Compound.
I stand the questions of form. You were asked about YSL, and the prosecutor, Love, asked you, are there Crips in YSL? Do you remember that?
Yes.
And are there Bloods in YSL? She asked you. Remember that?
Shit, I mean, a lot of questions. Huh?
That's fine. If you don't remember, it's fine. Or maybe I'm wrong. Okay. I want to talk to you about Jeffrey Williams, YSL. Okay?
Yeah.
Young Slime Life. That's a record label. You know that, right?
Yes.
And are you familiar? And if you're not, just say, Brian, I don't know. Okay? Does YSL produce music?
Yes.
Does YSL record label distribute music for public consumption? Consumption means for the public to listen to.
Yes.
Does YSL include music engineers?
Yes.
Does YSL include lawyers, business lawyers?
Yes.
Does YSL have managers?
Yes.
Do they have bookkeepers? That means people who keep all the money.
I mean, they got to it. That's a business.
If you don't know,
Yeah.
okay. Do you know if YSL pays taxes?
Yeah.
Do you know whether they're registered company in the state of Georgia?
Yes.
Do you know whether they were bought out by a publicly internationally traded company?
Your Honor, that's for basis I object.
Do you know that? It's public information if you know.
I sustain the question. It's been asked and answered too, Mr. Steele.
Do you know whether this record label that Jeffrey created, if he's a part of it?
Yes.
And are there people who do promotion and advertising
Yes.
and search for new artists, A&R,
Yes.
and people who promote interest in Young Thug brand?
Yes.
And Young Thug brand is something that you don't back down, no fear. That's what was created, right?
Objection is to speculation.
If you know.
I sustain the question.
In the
I see about Mr. Steele being a good lawyer. Yes, Mr. Steele is a renowned criminal defense lawyer. He is one of the expensive one, and he is expensive because he's good at it. He would be a lot better if he wasn't handcuffed by the judge.
public domain, that's what Young Thug brand is, right?
Yes, that's saying basic
I sustain the
speculation.
question.
I would like Mr. Kokomo, with his permission and the court's permission, to show privately Mr. Stevens that song, Let Me Live, to see if he knows the song, Your Honor.
Your Honor, I object.
That's the same question.
Okay.
Yeah, if you haven't subscribed yet, I would really appreciate it. And remember, give the
Did
thumbs up
Jeffrey ever give you
or down if
anything
you don't like it. As long as you give a thumbs.
in order to enable the stature or the respect or the benefit of any gang?
Objection, Your Honor.
Did he ever give you anything?
That's sustained. Mr. Steele, it's getting the point. It's asked and answered at this point as well.
Now, in Mr. Williams, number 4, the chat that's in evidence,
Yeah.
there were talk about, if you need to see it, we can put it up and hand it to you, okay? There was talk about Mr. Williams saying, I'm on this thread. Don't play with me. I'm a real gangster, for real. Don't talk like that behind my back because I'm here. You remember all those conversations? And Mr. Williams said, I pay for everything. Remember all? Mr. Williams paid for the $1,500 plan.
The court sound, I don't know why it acts up sometimes. It just does. And I can't do anything about it.
You were trying to write it down. Check 2, 3, 4. When Mr. Williams wrote it, he was everything. Well, I'll take it right. You're wrong.
Yeah.
I think it was at the studio, dinner, drinks, right?
Yeah.
I assume that the background noise we currently hear is the sound check or something. Checking the sound. And it leaked into the stream.
Mr. Williams funded criminal activity. You didn't know. May I have a second? You're honest. Honestly, because I was told. Mr. Stevens, the prosecutor was asking whether I visited those students. One of those questions. I asked them dates.
Yeah, as you can see, when I pause, that background noise is gone. It means that it's in the stream. I can't do anything about it. I wish I could. AJ Tyler, Nick, what do you think about the state constantly not disclosing all the witnesses and evidence and Judge Glanville consistently allowing it? I think it's pure garbage. And I've addressed it in, I think, most of my streams about the Young Thug trial. That it's a mockery of the justice system to constantly allow the prosecution to come in the middle of trial or really, really close with completely new evidence, not handing over discovery, refusing to hand over witness lists, adding to witness lists. They are ordered by the judge to trim down. It's infuriating to watch this mockery go on. That's my opinion.
What's that? Down there, right?
Have I ever?
Do we need one or we need it for your live stream?
No.
Do we have any type of relationship with attorney-client?
No.
Do you know that I've been with Jeffrey in other cases for 10 years?
Yes.
Do you know that Jeffrey put my name in song
Yeah.
Do you know whether he called you?
Oh, yeah, I'm on the way.
Yeah.
Does that have anything to do with Jeffrey Williams?
I was just trying to get somebody to represent me for my own probation reputation.
Good night, Gigi. Everybody say good night to Gigi. Gigi is my first and best moderator, and love her to death.
All right. Can we excuse Mr. Stevens?
And finally, Mr. Stevens is allowed to get off the witness stand. Finally. After, I think this is the 7th day he's on the stand. For something that should have been done in less than a day.
Can y'all approach for a second, please? Mr. Stevens.
And this would be sidebar counter number 64. It's laughable. Completely laughable. Let me check if... Okay, I see that the law and C words stream is without that infuriating background sound, so I'm switching over to their stream. And then they're on a break. And then they're back.
NICHOLAS. Sorry, I did.
Oh, we have a new witness. Finally. Let's listen to this new witness.
Nicholas Reed, NICHOLAS. Sorry, I did.
Officer Reed, good morning, or good afternoon, sir.
Good afternoon.
Sir,
Good afternoon. I currently work for a company called Arbonomics.
And what do you do, Carbonomics?
Just make grass look pretty.
Where did you work previously?
I used to be over at the solicitor's office and APD before that.
And how long were you with the solicitor's office?
For about a year.
How long were you with APD?
About 6 years, 5, 6 years.
If you can recall, what years did you work for APD?
2013 to about the end of 2018.
And what units were you assigned to while with APD?
I started out in Zone 3 and then worked over to the Apex unit and then Zone 4 after that.
So what years were you with Zone 3?
Zone 3 from 2013 to about 2015.
And what years were you with Zone 4?
2017 to 2018.
I haven't watched this part of the trial at
Oh,
all,
wait,
so
you're
this is as new to me
From about
as it is to you.
2015 to 2017.
What is the Apex unit?
Basically, it's a proactive policing unit. Go out, try and find violent repeat offenders, or make.
He claims he was sick. So, and it happened Tuesday after trial. He got sick and called the rest of the week off.
Drug cases.
Officer Reed, what was some of your responsibilities as a Zone 3 officer?
Just patrol, enforce the law. Respond to 911 calls.
And what area does that cover? What does Zone 3 cover? Control?
Which area did I cover?
Yeah, or Zone 3 officer.
For me, my particular area was up around Metropolitan, up toward Cleveland, down Sylvan, everything in between there.
And during your time as Zone 3 officer, were you post certified?
Yes.
I want to turn your attention to May 11, 2016. Did you respond to a call that you?
And here we go again with an 8-year-old case. I wonder which one this is. If this is one of the carjacking thingies, we all know nobody was charged with that. But it happened in or close to the YSL area. So the prosecution is allowed to get these things in.
45 Mall Drive.
I did.
Is that location in Fulton County?
Yes.
Were you in uniform?
Yes.
Were you wearing body cam?
No,
Why not?
they weren't issued.
What was the nature of the call that you responded to?
It was a carjacking.
Please say it's not the same carjacking, but it probably is. It's in the indictment as an underlying act. So far as I know, nobody of the defendants were charged with this. Nobody was brought to trial. Nobody was convicted. But the Georgia RICO Act allows these things to come in as underlying acts. And it's so stupid.
Tell the jury what happened once you arrived on scene.
So basically, the call that I got was a carjacking. A female had a weapon put in the face, a gun pointed in the face, and the suspect drove off with a vehicle and a purse.
Officer Reed, I'm showing you what's been marked as States Exhibit 29B. Do you recognize that?
Yes,
How do you recognize it?
that's the victim of the carjacking.
Okay. Is that a fair and accurate representation of the victim that you met with on the day?
Yes.
Your Honor, this time the state tenders States 29B for admission.
Any objection?
I think I do have an objection, but let's see that first. B, Dicker.
I do object. I object on the basis that it goes to identity. Identity is not an issue, especially not for a witness who's expected to testify.
Can I see it, please?
Let me get this straight. This is a carjacking where we heard from one witness, the 911 call, and now the responding officer, but the actual victim will not testify?
Okay, all right, here you go. Any further objections, sir? No. Okay, I'll rule the objection. Stage 29B will be admitted over your objection.
Thank you, Your Honor. Commissioner Thomas.
Maybe publish as you see fit.
Mr. Reed, who is, tell the jury who the photo is?
This is Mr.
Regarding the Georgia RICO Act, it has been upheld in Georgia Supreme Court, but it has never been challenged outside of Georgia. I would assume if the former president in his RICO, if it ever comes to trial, that he will challenge it all the way up to the Supreme Court.
Arabia Hill.
And you met with Ms. Hill on May 11, 2016, to your response to the project?
I did.
Where was Ms. Hill located when you met with her?
The location was a condominium. Condominium. So there's a parking lot. She was outside the parking lot when I pulled up.
Speak up.
The location.
Yeah. One of the witnesses for this carjacking says it took them 20 to 30 minutes to show up.
Was a condo, so when I pulled up, she was outside in the parking lot.
What was her demeanor like?
She was really frantic. You could tell, highly upset. Something bad happened before I got there.
Was anyone with her?
Her daughter.
What was her demeanor like?
But she was shook up as well. She was a little girl.
Yeah, we know all this, and I see AJ Taylor in the chat saying cross is good. So we know everything about this carjacking already through the 911 call and the witness. We don't need to hear it repeated a third time. So let's move up to cross-examination.
Basis. The admission of these photos on the fact that
Oh, this is still not the... Yeah. This is... Let's see here. Where did it go? Yeah. This is the alleged perpetrator that was arrested.
I have not met prior to today, right?
No,
I think we did have a chance to chat briefly outside in the hallway. Is that right?
that's it.
All right. You were with APD, if I heard you correctly, from 2013 to 2018. Is that about right?
Yes,
Okay. You were assigned to Zone 3 between 2013 and 2015.
yes,
This incident that you've been brought in to testify about occurred in May 11th, if I'm correct, of 2000 and is that 16 or 15?
Oh yeah, I forgot. Me and Dave are doing Yodi Aris trial, and sometimes direct examination is so boring that we force the chat to super chat us. And every $10, we jump 10 minutes up. But now, I don't mind super chats. I don't mind gifted memberships and stuff like that. Because that is what keeps this channel afloat. I've said this earlier on different streams that I need roughly $350 a month to keep this channel afloat. That's break even for me. So if you have the means, but here's the thing: don't you ever dare to give something you can't afford. Don't you dare.
say again.
When did this incident occur?
16,
Okay. May 11th?
from what it says on the paper, on the report, that's what I know.
Sounds about right. You've not been a law enforcement officer since 2018, is that right?
No,
Okay. And so in terms of coming in here to testify today, you've had to refresh your recollection based on your report or the reports that were written back in 2016, right?
Mhm.
Yes?
yes,
Okay. You got to say yes or no so the court reporter can pick it up.
yes.
All right. That's good. Did you write a report yourself or was it written by other officers?
I wrote my portion of it, yes,
Okay. And then Officer, what's his name? Floyd wrote the other report?
yes.
There would have been a CAD report, a 911 printout, that sort of thing?
It should be. I mean, we just do the narrative and, just update whatever information we need to do. But as far as the CAD, I think that's something that the dispatcher, another part will handle, communications.
You did take out warrants, though?
Yes,
Okay. And those would have been several warrants taken out by you that would have had a little blurb about what the person is charged with, the basis for the charge, and the date, and your signature, that sort of thing, and the judge's signature.
yes,
Okay. Now, so in coming in here today, I think I heard you say, correct me if I'm wrong, that you had a chance to review the reports from back in 2016, right? Okay. You knew then that you were coming in to testify in this trial. Did you know how it was laid out in the indictment, the exact charge and who you were testifying about? Do you know that?
I knew who I was testifying about, and I knew I was coming to testify in regards to a carjacking. Yes.
Right. A carjacking that, and you knew it to be, at least in the indictment, a part of some supposed racketeering or RICO charge, right? You knew that?
No.
You did not?
I know what this trial's about, but again, I'm just here to speak on just the carjacking and Mr. Effinger. That's it.
The only thing it's in, again, correct me if I'm wrong, the only thing that you know, right, in totality is that there was a carjacking, right? You responded and you were involved in the investigation of that carjacking, right? And the person, Christian Eppinger, was ultimately charged with that carjacking.
Okay.
Yes.
And he was the only person charged.
Okay, so there was somebody charged with this carjacking. Okay. There are more than one carjacking then, apparently.
But he was the only one that had in custody, yes.
Okay, he was the only one caught, right? So what you know is that May 11th, sometime in the afternoon, you respond, you speak to Taravia Hill. That's the, you gotta say yeah.
Say again?
You gotta say yes or no.
Yes.
Okay, for the court recorder. And let's see, where are those pictures that we, here we go. And
From Hip Hop Press 365. Welcome back. Question. Do you believe Mr. Steele was asking questions strategically that he perceived would be objected by the prosecution and backed by the judge to display this is not a fair trial to the jury? Yes. I think once he realized his questions would be objected to and sustained, he reformulated it slightly just to get the words into the jury's ears. Now, that is a known tactic, but don't go overboard with it so you get reprimanded by the judge. So, yes, I do believe that that half hour of cross-examination or recross, that he knew he wasn't going to get the answers from Mr. Stevens. So strategically, he asked the question, knowing he wouldn't be allowed to have an answer to it. Thank you for your question, Hip Hop Press 365.
All right. Ms. Hill, this picture that was shown a little earlier, that's the lady who you responded, who you spoke to, is that right?
Yes.
She was the subject of the carjacking. She's the person who was essentially assaulted by that person with a gun, right?
Mm-hmm.
Her and her daughter.
Yes.
And she called the police. Either she or her neighbor called the police, right?
Yes.
And you responded. You spoke to her, and another officer actually is the one who made contact with the vehicle that had been taken from Ms. Hill.
Yes.
Okay. This was a carjacking, right? You didn't know anything about the case other than that. Objection, Your Honor. That's an answer.
I'm allowed to finish the question first. Go ahead.
You didn't know anything about the individual, right? Other than this person had carjacked a woman, right?
Right.
Okay. So you respond. Officer Floyd gets behind and ultimately arrests the person, Christian Eppinger, right?
Yes.
There were no other people arrested in the vehicle that he was in, the stolen vehicle, right?
No.
In fact, there were no other people arrested.
No.
Right? Did you say that you're the one who actually took custody of Mr. Eppinger, Christian Eppinger, and took him to precinct or took him to YDC?
I took him to YDC.
Okay. Now, you said he was wearing a blue jean jacket? Is that what you said?
A jean jacket of some sort. That's all I remember.
Okay. You remember the color of his pants or anything like that?
No, sir.
No bandana, no scarf, no anything hanging out of his pocket, nothing like that.
No, sir.
Just some kid who had just done a carjacking with a blue jean jacket and a pair of pants on and shoes, presumably.
I mean, if you're asking me to try to remember something from 9 years ago, most I can remember is that jean jacket, and that's it.
Okay. All right. So at the time that he was arrested and taken into custody, I think you went to the location, right, where he was actually in custody. You took Ms. Hill over there.
Yes.
Okay. Ms. Hill identified, she said, that's the guy who carjacked me, right?
Yes.
All right. Now, you don't have any personal knowledge that this person, Christian Eppinger, was doing anything in furtherance of any sort of conspiracy. Do you? Was the objection, please? Speculation.
I stand the question.
Well, I'm asking if he has any personal knowledge, Judge.
All right, I'll allow that.
Right. Do you have any personal knowledge that this Christian Eppinger guy was doing this carjacking in furtherance of any sort of conspiracy?
No, sir.
All right. What you know is that you got a kid, young man, whatever, who comes in, does a carjacking, he gets arrested, and he's taken to YDC, right?
Yes, sir.
And although you asked to, you identified these pictures of him. That's how he looked on that day, right?
Yes, sir.
Was he interviewed? And I don't want you to say what anyone said, but was there a detective who came to see Mr. Eppinger? Do you know?
Not that I can remember, no, sir.
Okay. You didn't have any conversation with him?
Nothing one-on-one.
Okay.
No, sir.
You asked earlier and about the distance from where the incident occurred, right, to where he was actually ultimately arrested. I think you said 6 to 7 miles. Is that about right?
Yes.
Now, it would be fair to say, and I'm asking you now to kind of base your answer to this question on your experience as a police officer, that carjackings occur all over the city of Atlanta, right?
Yes.
I mean, this was on Amal Drive, but there are carjackings that occur in Buckhead, in Southwest Atlanta, in Alpharetta, all over the city. A carjacking can occur, right?
Yes.
There is nothing, strike that, let me ask that a different way. There's nothing to suggest in this case, I'm just asking what you know about this case, nothing to suggest that this was a carjacking that couldn't have taken place. Improper question?
I stand objection.
All right, well, it happened on a mall drive, but it could have happened anywhere, right?
Yes, sir.
All right. This kid, Christian Eppinger, he's not in this courtroom. You don't see him, right?
No.
All right. Same pictures from back then. You don't see this kid. These pictures that they're showing, you don't see this kid anywhere sitting in the courtroom, do you?
Objection, Your Honor. Ask and answer.
I stand the question.
All right. You don't have any personal knowledge that this carjacking that occurred back on May 11th of 2016 had any connection whatsoever with Jeffrey Williams, do you?
No, sir.
You don't have any personal knowledge that this carjacking that occurred back on May 11th of 2016 had anything to do with anybody else in this courtroom, do you?
No, sir.
When he was arrested, you took out a warrant, right? And you took out a warrant for hijacking a motor vehicle, right?
Yes, sir.
Took out a warrant for fleeing, attempting to elude.
Yes, sir.
What you did not take out was a warrant for any sort of violation of the Anti-Gang or Terrorism Act. No gang charges. You didn't take out any gang charges, right?
No, sir.
And that is because you saw no basis to take out that charge, correct?
Correct.
I mean, this is 2016. You'd been an officer for 3 years at that point.
Yeah, as AJ Taylor says, boom, jury saw this as nothing to do with nothing. Yeah, and this is not the first time this has happened regarding alleged crime from that area. And they've asked the cops, was it anybody of these? No. But there are crimes that are in or near that area. And according to the prosecution, that's enough for it to be an underlying act in this trial. It's not a charge in itself. It's an underlying act under the RICO charge. And it's stupid.
You worked in zone 3. You knew what a gang-related act or gang-related crime is, right?
Yes, sir.
Because, you got to make notations of what you think is actually going on in a particular circumstance, right?
Yes, sir.
And you could have done that, but you did not, right?
I didn't see any reason. Say again? Oh, I didn't see any reason for anything like that.
There was nothing about this kid, no matter how he looked, or the evidence, or the statement, or anything in your investigation that led you to think, hey, this has something to do with some kind of gang, right?
No, sir.
In 2016, we're in 2024. So a little under 8 years ago is when this incident occurred, right? Yes?
Yes.
Since then, did you have to go to court in regards to this case?
Just today.
Just today?
Yes, sir.
From 2016 to today? First time you've shown up in the court to answer any questions about this or been called?
As far as I can remember.
Okay, all right.
Yeah. Now they had the kid charged, but apparently never got to trial. This officer or former officer never had to testify in trial. And as I said, there was nothing about that kid that told this officer he was a member of a gang or did it to promote a gang, because carjackings apparently back then, or now, I don't know, happened all over Atlanta. Diana Davis, hi new sub, finally catching alive. Although I'm really late, saw try earlier and have many questions about that video interview that judge won't allow in. Yeah, it is infuriating.
It's the first time DA's office ever contacted you and said, hey, we need you to come in and talk about this case from back in 2016, right?
As far as I know.
I'll allow it.
Okay. He's answered. That's all I have.
That was a good cross-examination, showing, and this with the witness and the 911 call, they can't say it has anything to do with Mr. Williams or any other of the defendants. The cop on the stand says that. Yet it's there as an underlying act or overt act.
Hold on. Anybody else have any questions? All right. Yeah, you have redirect now?
Yes, briefly. Officer Reed, were you trained to investigate gang activity?
Say again.
Are you trained to investigate gang activity?
Gang activity?
Are you trained to investigate?
No, I haven't got any training on that.
Now I'm publishing 18B.
So why do you have him on the stand then? Seriously. Now you're impeaching your own witness? The person you have on the stand in order to prove criminal conspiracy under the RICO Act, you're now impeaching by saying he doesn't have gang training in gang activity. Do you believe, Hip Hop Press 365, do you believe the defense will file a motion to recuse the judge? If so, how long is the process? If they wanted, they would have done that already. I think they know that it will be denied either way. And that they have enough for a possible appeal as appellate issues regarding his conduct. Maybe at some point after, if they file such a motion, it will probably be during the defense case in chief, depending on his rulings there, because then they have all his decisions during the state's case in chief to rely on. So if the judge starts to contradict his prior rulings, then they might have something to go on. And and we still don't know if, because they're already down 1 or 2 euros, I don't remember which one it is. This trial, in my opinion, will last a year. And they're already down euros. I don't think, statistically, people will go. Accidents happen. People get sick. People die of age. I mean, statistically, there's a high chance there won't be enough euros halfway through this trial. What happens then? It will be declared a mistrial. And I would assume that the prosecution will file for a new trial, and then we start all over again with jury selections. And the last time it took 11 months for jury selections. Yeah, this isn't the first prosecution with this, the first prosecutional team with this.
Are you able to make out any marks on Mr. Evanger's face?
I mean, I see a mark, but I can't.
I'll sustain the objection.
Do you see anything on his face?
I
I
sustain
just
the
see a mark
objection.
on the face right
Hold on,
now.
hold on. Sustain the objection. Ask something else.
Officer Reed, was Mr. Evanger the only person reportedly involved in this carjacking?
According to witnesses, there was another car that had other individuals in it that followed the black Toyota, but they must have went opposite direction because, like I said, the only thing
Hold on. I sustain the objection. It's speculation by Mr. Matthews. And I believe Ms. Westmoreland, but her grounds were not determinable. But anyways, I'll sustain the objection.
Officer Reed, how many people were you on the lookout for after talking to Ms. Hill?
One in particular. Mr. Eppinger, because that's the one that I had all my attention drawn toward from what the victim was telling me. As far as who took the vehicle. Like, yes, she said there were other people in the vehicles, in the second vehicle, but like I said, we're more concerned about trying to get the actual person inside the Toyota.
And were you also looking for another car besides the Steele's vehicle?
There was a tan and color car. That's all I can remember about that one. Though.
Do you know any more about Mr. Edmonds' accounts?
No.
That's very good.
Anything further, Mr. Adams?
Yes, sir.
Thank you. That's just, I'll say one or two more questions, but I want to be held to that. So just a few
Well, I'm
questions.
gonna hold you to it.
Well, so 4 or 5 questions.
So, okay, that's 5. I'll give you 5, okay? That's the upper limit. Come on now.
Number one. All right. You had information about other people in the car that this kid Eppinger got out of, right?
Yes, sir.
Those other individuals were never apprehended. No one else was apprehended other than Mr. Eppinger, right?
As far as that day, that's all I know, Mr. Eppinger.
Okay. It is impossible to say what, if any, role those people in that car had in this carjacking, right?
I don't know.
It is impossible to say who those people in that car were, right?
I don't have any idea.
Okay. And you're not aware of there ever being any arrest of anyone else for this incident, this carjacking from May 11th of 2016, other than Christian Eppinger, right?
No.
All right. Was that 4? Okay. Thank you. That's all.
Thank you, Mr. Adams. Anybody else? Okay. Anything further, sir?
No, you're
All right. All right. May Officer Mr. Reed be permanently.
Okay, again, completely useless testimony for this trial. And remember, the prosecution's witness list, 731 witnesses. This is one of them they chose to be important to this trial. Now imagine the quality of the rest of them. I covered one of the Daubert hearings regarding one of the experts the prosecution wanted in as a forensic video analyst. That sounds really important. You know, looky, checky, blah, 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 whatever's. During the voir dire, the examination of him as an expert, he testified to that the only thing he does, he gets a video from the cops, plays it to the timestamp, takes a screenshot, put that screenshot in Photoshop, and enhances the part the cops want enhanced. That is the entirety of what that guy did. And the prosecution wanted him in as a forensic video analyst. Now, they didn't succeed, but he was still let in as an expert in video enhancing. That's the level of competence the prosecution shows as an expert witness. And I can't wait for when they put that guy on the stand. It will be a slaughter from the defense. They will rip that guy's testimony apart. And I can't wait for when that happens. Now, they did have a bit of hearing, the final part here.
Brittany Scott with the GBI. And we will have Officer Andre Bent, who will be for February 25th. We also, to finish and conclude Act 61, we have Officer N. Reed. Excuse me, Officer Floyd.
Yeah, this is the prosecution going through the next witnesses, what they plan to do the next few weeks, and everything. And see, looking here for Oh, listen to Steele, says AJ Tyler. When is that going to happen?
Then next week.
On,
Mr. Steele.
Your Honor, we would need a hearing on the character evidence from February 25, 2014, Officer Bent involvement. I believe that deals with Mr. Williams allegedly with Mr. Walter Murphy, supposedly in a car and driving around a McDonald's, the McDonald's that's mentioned in this case. A gun was supposedly thrown out of the car. The surveillance video, I don't have that surveillance video. I've asked for it. The officer said that after searching or watching the video, he then made a determination that Mr. Williams threw the gun out of the car. And I believe, I'm not looking at my documents, but I believe Mr. Williams entered a nolo contendere plea. I believe I represented Mr. Williams. And if my memory is locked in correctly, then that was a nolo contendere.
Just for information, during these last minutes, I'm putting monetization on this stream, which means that you might get an ad. You probably won't, but you might get an ad. That brings me a few cents. But I haven't had it on for the entire first 3 hours of this, so it gives me half a cup of coffee.
Contendere plea and a nolo plea cannot be used in a trial, so I would be objecting to any entrance of that, but I do have to check. I have a certified copy somewhere. But anyway, we need a hearing on it. We don't believe that it's intrinsic act evidence. I did not get any type of 404B evidence. There is nothing. I searched, by the way, for any type of no notice has to be given in a RICO conspiracy case for an overt act. It says the opposite. The criminally accused is entitled to, by the Constitution, to be placed on notice of what the overt acts are. So I will be objecting to the admission of that. In addition to that, then you get to, and I know it's later in the day, but Investigator Belknap, and that's what we were talking about this morning when we started. I have nothing from Detective Belknap on a report. I've never had a report from him, and that violates the Honorable Court's order that I gave to the Honorable Court's co-worker, the Honorable Mr. Kearns. It was dated, court entered on 11/17/2023. In the second paragraph, it's a one-page document. Court wrote again, additionally, all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each party, each person accused in stanter. That has been violated. So I'm going to move to exclude Detective Belknap. I'm also going to adopt the other lawyers. I believe it was Mr. Shard and Mr. Weinstein, but if I'm wrong, I apologize, who said that it's just becoming like the Detective Belknap case, where he's just coming in consistently to say, now let me tell you what you heard and why it matters as an expert. So I'm objecting to that.
Okay, we haven't gotten to Belknap. We covered that last week on Tuesday. So until that occurs, I'm going to push that conversation a little.
Again, he does this all the time. He moves stuff forward until it's happening, and then he gets angry at the defense for not bringing it up sooner. And the defense tries and tries and tries and tries to bring things up in a timely manner. And the judge keeps pushing it forward, pushing it forward.
A little bit. But the other issues in regards to the potential hearing as to character evidence. Who is the witness again? You're trying to call that you think is going to get that, elicit that?
Your Honor, thank you. The witness is Officer Andre Bent with the Atlanta.
Gant, G-A-N-T?
B-E-N-T, Bravo, Echo.
Bent, so not Gant.
Correct.
Bent?
Correct. Bent.
Okay.
Bent.
Okay, Officer Bent. And what is he testifying to?
The state's position, number one, is that it is not improper character evidence. It's not.
Answer my question first.
He will be testifying that
Okay.
on the date alleged, the defendant was in a car with another a YSL member, Walter Murphy, and he saw the defendant driving in drag in circles around the McDonald's parking lot on Cleveland Avenue. When he attempted to conduct a traffic stop, the defendant, Jeffrey Williams, threw a gun out of the window. He saw him throw the gun out of the window. This proves one of the.
Yeah, isn't that convenient? That's like, I mean, it's like, oh, I smelled marijuana or something of that sort. And once cross-examined, okay, you were in your cop car, yes. And that other car was driving past you, yes. And you still managed to smell marijuana, yes. And somehow cops' noses are evidence. It's so stupid. It's so incredibly stupid. And I saw him throw a gun. Well, congratulations. Evidence, please.
Elements of count one in terms of the association. It also, as to the defendant Williams' actions regarding that firearm, this is another instance of him acting unlawfully as it relates to the firearm, which goes to, again, show not only the aspect of association, but the actions as it relates to the conspiracy. These are intrinsic acts. I won't get into further offering of how we believe that it's admissible until the court tells me to do so.
Okay. Is a plea going to be entered or was it entered or offered as part of this particular testimony?
No, Your Honor. As a matter of fact, the no-low plea itself, I believe, would not be admissible by either side.
Okay.
So
That's not an issue. So
Correct.
So the question, Mr. Steele, is they're asking for it to be admitted to prove allegations in count one, firearm and association.
Which is propensity and character.
No, it wouldn't be propensity. I mean, they're not going to issue the NOLO is not, it's test, assuming they lay the foundation, if I'm hearing it correctly, it's a traffic stop in regards to Mr. Williams and Mr. Murphy in a vehicle where there's an allegation of a potential firearm being thrown out the window. Is that correct?
That's my understanding of the facts.
Okay. All right. So what's your objection based upon that?
Three things. First of all, it is not in contention that Mr. Williams and Mr. Murphy were raised together and associated together. There are chats that are already in evidence, that they're on the same chats that have been identified. There is going to be statements made by Mr. Murphy, because I'm told by the prosecution he'll be a witness in the case because he pled guilty with the Honorable Jacoby Hudson representing him. He made prior statements talking about how he knows Mr. Williams and how they grew up together. He will.
Are you talking about he being Walter Murphy or? Okay, but this is the witness, Officer Bent. That's what I want to focus on.
The association prosecution is arguing is between Mr. Williams and Mr. Murphy. And I'm saying there's no reason to put in the character that Mr. Williams was laying drag and then a gun came out of the car to show the association between Mr. Murphy and Mr. Williams. That will be proven. In fact, we will stipulate to that. We're not going to argue against it. What the state is doing, though, is then they're looping it up into, and a gun came out of the car to argue that is a criminal conduct. Throwing a gun out of a car is reckless conduct. And that is why I'm objecting. That is a crime. In addition, the state is saying that they won't get into it, but it's intrinsic act evidence. So therefore, they didn't have to give notice because no notice is given. Intrinsic act evidence, as the court is aware, means it's intrinsically intertwined. You can't tell the story of this RICO conspiracy without that evidence. That's just simply a fallacy. That is.
Okay, so apparently this piece of evidence, I'm not entirely sure. Here's the thing, I'm not a US-based one, but yeah, I don't know.
Made up. There is no way that this case would ever be held up because a 2014 February 25 gun thrown out of a car on Cleveland Avenue was not introduced. The story has 191 acts already. The state is just consistently making.
Oh, they are adding to it. Okay. Nobody is surprised with the prosecution adding things into the RICO charge. Nobody is surprised. And as the defense said, there's 191 underlying acts or overt acts under the RICO charge. And the quality of that we just heard from the previous witness.
In this case, too big for a jury to understand. This case is cumbersome. And 403 states that if it is confusion and adding confusion to the issues, then it doesn't come in even to intrinsic. That's even intrinsic. But I'm saying it's not intrinsic. Your Honor, there's nothing needed to complete the story or to show the motivation for the next issue by a gun coming out of a car. So those are for all those reasons. And I'm trying to limit the amount of time that we are dealing with the jury because the court's here too. I'm looking at the jurors. This is a lot of information. I hear the court say they need more books. This is a lot of information. This should not come in. This is violation of 403. It's in your discretion. I'm very aware, but in my opinion, my advocacy, it's a violation of 403. It is not intrinsic. It is other act evidence. And I never got notice of it. And there's no such thing as we needed to prove the association because the association between Mr. Williams and Mr. Walter Murphy was conceded, never contested, and I'll even stipulate to it. And I know the state doesn't have to accept my stipulation. I'm well aware. But I'm saying it's proven. It is going to be proven in and among itself with the evidence in this case. If you look at other overt acts, it is coming. Mr. Murphy and Mr. Williams are friends, associates. In fact, which I'm objecting to, but I heard what the court said, the tweets have Mr. Murphy, he's DK, something underscore DK, and Mr. Williams constantly saying, and Mr. Williams, over my objection,
Okay. So this is the prosecution wants to show the association between these two gentlemen, and they want to show it through this Officer Bent. But they already stipulated, and the other evidence already show they know each other.
Who's going to come in, follow my blood, DK. I mean, the state doesn't need Officer Bent, and it's a waste of the judicial resources that we hold precious, and its character.
So are you saying his character because there's a firearm that's thrown out the window? Okay, fine, okay.
Arrested heaving Officer Bent,
Okay.
arrested Mr. Williams for discarding a firearm. And if I didn't make this clear, Officer Bent relies on a surveillance video from McDonald's. I've asked for that. I've asked for it written.
Has it been produced?
Right,
Has it been produced?
right, never. And I'd like to see that video.
Oh! So the cop relies on a surveillance video that has never been produced.
Because if it didn't come from Mr. Williams, that's a whole different story. Then I'm going to argue, why is it coming in at all to show Mr. Murphy? I've never seen it, so I'm relying upon Officer Bent. And I'm not criticizing him at all. I'm just saying, I've learned, you look at evidence, you speak with witnesses, you do research on law. I can't see the evidence.
All right, let's deal with it first we begin with. Do we have the McDonald's video?
No, Your Honor. We have Mr. Officer Bent seeing the defendant throwing a black object out of the window.
Does he rely upon a video?
No, he
He saw a black object. That's different than a gun.
actually only relies upon the video to see the spot, to locate the spot where he saw the defendant throw the gun out of the window. He does not rely on the video. He goes and finds the.
Well, we don't have the video though.
We don't, right.
We don't have the video. Why? Why? We don't have the video. Why?
It does not, to our knowledge, exist at this time.
Is it gone at this point in time, not preserved?
I believe that it is not preserved, but we also have the fact that Officer Bent saw him tossing the gun out of the window, and he also went to the.
Now she's going back and forth between dark object and gun.
That space and picked up the gun. We have statements that were made by the defendant.
Yeah, but for everyone who is here, this is an argument in front of the judge alone. The jury has been excused by this time.
Walter Murphy and Jeffrey Williams, as it relates to the gun. There's no question that the defendant threw the gun out of the window. Officer Bent saw him do it. Okay. We would ask the court to allow us, if more argument is needed, to allow us to come in early in the morning before the jury gets here to address it.
Here's the thing. If the cop only saw a dark object being thrown out of the window, and then somewhere in that area there was a gun, they need to show that these two are connected. And that they can do with a video who wasn't preserved.
But Your Honor, it's we have, I believe, talked about it previously because I believe that Mr. Steele had actually requested the video previously. I'm not going to say that with certainty, but as he spoke just now, I'm reminded of a similar argument regarding the video, and we told him the video didn't exist. So for him to say he didn't know about this act is not accurate.
Well, I think I think that the 2016 McDonald's video, it does not exist. I mean, I don't know if it's subject to the hack that we had evidence of earlier. But anyways, okay, what's the relevance of the firearm though?
And so, Your Honor, to further, this goes back to arguments that were made during the course of our prior motions. I think it was related to matters that we were arguing while we were dealing with the legal issue. But Your Honor, the firearm, the defendant's actions as it relates to the firearm, and who the defendant was with and what actions he took while with him are all actions and evidence that the state argues would go to prove count one, the conspiracy. They're trying to get rid of a gun that they don't believe they should have. This is a consistent theme throughout. It's not improper character evidence because it is evidence of a crime that we're alleging in the indictment. The argument has been made previously that intrinsic acts has been couched that these acts are character evidence, and the court has previously found, we believe rightly, that they are not improper character evidence just because they reflect poorly on the defendant's character. I believe that the courts have consistently said when you're offering up proof of a crime, it necessarily reflects poorly on the character, but that does not make it inadmissible. It is intrinsic, and we can send to the court and to Mr. Steele that case law that once again says that very thing. And again, for Mr. Steele to argue that we have other ways of proving later on, we have to prove our case in its entirety in our case in chief. We can't wait or hope for something else to come up. And we ask that the court allow us to we're going to have a full-fledged hearing on it.
I don't need one. I'm good. Okay. All right. Mr. Steele, at this point in time, with anything else, I'm gonna allow it. Assuming the fact.
Of course he is. Of course he's going to allow it. Of course he's going to allow it.
Foundation is laid for what Officer Bent saw. So at this point.
Can I just tell you something that I'd like you to, as we leave, just consider?
Sure, sir.
Thank you, sir. I listened intently. I never said anything like I didn't know about it. I, in fact, argued the motion that I want this surveillance video from the McDonald's.
I recall that, sir.
Thank you. This is what the report says. It's a one-page report by Officer Bent, Your Honor. And I'm just reading one paragraph. It says, during the time when I lost sight of Mr. Williams around the parking lot, Mr. Williams threw a weapon, in parentheses, Smith & Wesson 9mm, close.
Oh. So during the time, that's an interesting report. Because if the cop lost sight of them, and then he states a gun was thrown out. Well, if it was during you lost sight of them, then you didn't see it. I'm wondering here if this is what happened. Lost sight, found them, stopped them, searched the area, found a gun. And he assumed it was thrown from the car. But he didn't actually see it. And that's why the video from the McDonald's was so important, because that would connect the two. But without the video, there's no connection. Then it shouldn't be allowed in.
Parentheses, outside of the vehicle, which was also captured by McDonald's video surveillance. The firearm was silver and black in color and was loaded with 14 bullets. The gentleman did not see it come out of the car as you're being told. You're constantly being told wrong information, and I'm sure it's.
Well, I think that what you just read me says he saw it. The officer saw it, and it said it was also captured on McDonald's video.
No.
Did I read that again?
I said it wrong. During the time when I lost sight of Mr. Williams around the parking lot, Mr. Williams threw a weapon, Smith & Wesson 9mm, outside the vehicle, which was also captured by McDonald's video surveillance. He lost sight of the vehicle.
Okay.
The point I'm trying to make, Your Honor, is then the next thing is I am going to challenge, and I was never served with it, so I don't know why I have to challenge it. But I was never served with Mr. Williams' statement. The state never said to me, we're going to try to introduce this statement. He is in custody, and he gives a statement. There's also one Xanax pill found in the car. I don't know how that promotes anything, so I'm going to move to exclude that. So we will spend as much time as the court allows to do this case when it is not necessary to do anything. It is not intrinsic. And that's what the state is saying. The state has put in, every time Mr. Williams has been arrested, they're trying to get that in. They should have put it as an overt act in the indictment, and I'm kind of stuck with it. But they didn't. So I'm moving to exclude this particular act. And I know it's a little act to the court. I know what you see. And I know you said, so what is a gun thrown out of a car? But for all the reasons I said, and including confusing the issues, and it's just character evidence, I would like to exclude this. And I promise you that evidence will come in that we'll not object to that shows that Mr. Williams and Mr. Murphy have a relationship. There's no way around it. I would not tell the court differently. But for Ms. Love to get up, and I know it was unintentional, but to say that Officer Bent, on 2 occasions saw this with his own eyes, that's not what the report says. And this is also going back 10 years. It's a 10-year-old case, and I don't have the video. So for all those reasons, or any one of them, I ask the court to exercise discretion and not admit this other bad act evidence.
Can I see the report?
Yes, Your Honor, Mr. Steele has it. And I will also say.
He's got it on his computer, I think, though, but.
Because ours is on the computer. We can bring up the report.
Jesus Christ, Miss Love, just hand over it. Don't talk while doing it.
Okay.
And Your Honor, if I may, while we're readying that for the court.
All right, Mr. Steele, let me look at it.
Mr. Bent has been on the witness list. Mr. Bent has literally told us that he saw the defendant, Williams, throwing a glass.
Oh, he told you? But he conveniently... Did he told you after he knew that the video doesn't exist? Is that what happened, Miss Love? After you found out that the video non-existent, lost in transit, erased by mistake, whatever, is it after that he told you, oh, but I saw it? Here's the thing. In his reports, if it's verbatim, what the defense said, it should be thrown out.
Object out of the window. We would not say that if we did not have basis for that statement. The argument that we have enough evidence will come in as the association still does not take away the state's big, huge burden of proving every element of every charge in this indictment beyond a reasonable doubt. And I thought that I heard Mr. Steele say he had no notice, and in the same breath say he argued it previously. So if I misrepresented something, that is my mistake. But Mr. Steele or Mr. Smith will bring to the court the report that we're talking about. But we have also provided to the defense the name, phone number, and contact information, and every ability, if they choose to speak with Officer Bent.
Now that's burden shifting. You have the burden of proof, Miss Love. The state has. Handing that over to the defense. Oh, they could have spoken to him. They don't have to. They have the police report. If this police officer now claims 10 years later something else that's in the report, that inconsistent statements, and since the video is non-existent, that should be thrown out.
Speak with him, and I'm certain he will tell them the same thing that he has told us. But the matter that it's not in a report is a matter for cross-examination, and it does not make. And I'm glad that Mr. Steele reminded me that there are drugs in the car, illegal drugs, to which no one claimed a prescription, because that in itself makes having that firearm during the possession of a controlled substance exactly the kind of crimes that
This is infuriating.
Defendants in this case, and that this conspiracy alleged in count 1 consists of. So it is intrinsic. It does prove and go to prove elements of the crimes alleged in this case. And we have previously.
All she was asked to do was to hand over the report, and she's incapable of shutting up and just do what the judge says. And here's what's infuriating. The judge allows her. Had this been the defense, he would have yelled them out of their socks.
And we would ask the court allow us to introduce it. Like I said, we need to provide or bring to Mr. Steele, Officer Andre Bent. We can do that too, but he's told us what we've represented to the court. And this video that Mr. Steele has asked for and has previously asked for, we don't have. But Officer Bent will be able to testify as to what he saw the defendant do. And the person with Mr. Williams also made statements that we will, of course, ask him about when he is on the stand.
Excuse me? Let me go back a few seconds.
But Officer Bent will be able to testify as to what he saw the defendant do. And the person with Mr. Williams also made statements that we will, of course, ask him about when he is on the stand.
Yeah, let's.
And whether we have to impeach him later or not is a matter, up to that witness. We don't know what people will do until they're here.
Skip ahead a bit.
Mr. Steele, thank you. All right. I'm going to reserve ruling until Officer Bent testifies in terms of, I believe that his testimony would be relevant. What he's written in his police report in terms of his ability to perceive the incident would be subject to cross-examination and go to weight more than it would be anything else. In terms of it,
And it's saddening,
the
but I'm
firearm,
not
in terms of
surprised.
association, certainly he could testify about that. Certainly can testify to the circumstances surrounding his interactions with Mr. Murphy and Mr. Williams. In terms of the firearm, if that's the case, it also too is an issue of whether or not it existed and whether or not Mr. Williams or Mr. Murphy had it. And so, I mean, that's what I would say at this point in time. I move for the exclusion of any mention of Xanax pill. I don't have any notice of a crime lab report in this case or a witness in this case, so I don't know what it is. I don't want to take some Xanax. Yeah, is there a report?
Your Honor, there's not a report, and Your Honor, it would be Officer Bent's lay opinion as to what it is. I believe that would be another matter for cross-examination and go to the weight not be admissibility, assuming the state can lay a foundation.
Is he going to testify about pills, or how does he know it's Xanax?
It's markings, the way that generally when the GBI gets these type of pills, they can look at the markings, the color, the size, the shape. And again,
It's from my alcohol cabinet.
It can't lay proper
I can't afford therapy, but I can afford
I would think
whiskey.
that you probably need to ask him. Is Xanax one of those drugs that has it imprinted on the drug?
I believe it does. I will find out from Officer Bent. And now, so Officer Bent will be able to explain to us outside the presence of the jury.
So everything comes down to what this officer says 10 years later after he finds out that evidence has been lost. And then all of a sudden he changes his statements. That is what you should do, Your Honor, but I know you won't.
And to the court, give the court satisfaction what it is that allowed him to form the opinion that it's Xanax. I believe that would respond to the court's concerns.
He won't know it's Xanax, and I mean, he can't really testify about that. Only somebody from GBI or a professional witness would have to testify about that. He probably testified he found pills,
That was consistent.
not in an open container or not in a prescription bottle.
And he could describe it and he could state that it is consistent based on, I believe, a proper foundation he's given.
It depends upon what his training and qualifications would be in terms of that. But
And I won't even try unless outside the presence of the jury, the court heard him and he tells the court or I come back and tell the court what his basis for that opinion is. And
why don't you ask him first tomorrow,
yes, sir.
and let Mr. Steele talk? And do you talk to Officer Bent?
I'd like to.
Okay, all right. Why don't you all do that, and I can rule on the issue of whether or not that's the drugs in the vehicle. Okay.
Yes, Your Honor.
All right. Anything else? Oh, do we have any scientific testing in terms of that?
No, the court asked, we don't have a GBI contact to Officer Bent to be able to say that based on his training and the court will hear it, and be able to present to the court, it was consistent with being Xanax, and that coupled with the defendant's action.
I don't know. I think you're gonna need to have a scientific test on that one.
Also, it's similar to, of course, Your Honor, when there's marijuana in the car and officers make an opinion about what it is based on their training and experience. We would ask the court allows the opportunity to simply present prior to us even asking him about it, just an additional proffer to the court based on our conversations about this first thing in the morning or later tonight via email to all the parties as we've been doing and the court.
This is so
Anything
stupid.
further, Mr. Steele?
I have no way to test the pill.
That's my concern, Ms. Love, is that you don't have any other basis. It'll just be out there like, well, the jury's got to decide whether or not it's drugs or not. So without anything more, I'm going to pass on that one. I think it opens up too much of an issue. So unless you've got somebody to test, that drug's been tested, we know what it is. I'm not going to permit him to testify about that. Okay. Anything else?
No, I'll speak with Officer Ben. I assume tonight or tomorrow the state will let me know.
We have given to, Mr. Officer Ben is available whenever Mr. Steele wants to call him. We've already spoken with him. We've given him the phone number for him. He's available at any
Okay.
time. I believe we've also represented that to counsel for the defendant as we've been doing on an ongoing basis with all of you.
Okay.
Mr. McCracken, why at this stage of the trial are they even debating on admitting new evidence? Because the prosecution knows this judge will let it in. Even though it's a month, almost a month and a half into this trial, they are moving in new witnesses, new testimony, new everything. Oh, look who's awake. Hello, Mr. Jingles. Here's Mr. Jingles. Hello. Look at my happy cat. Look at my, he really enjoys when I'm doing this, and he will not at all try to kill me. Yeah, so if you wonder where this little thing comes from, that's Mr. Jingles. And we are all a part of Jingles Viking Thugs. Yeah, I mean, I have never seen anything like this. And it's infuriating because for me, the way this trial is conducted goes against every hour I spent getting a law degree. It speaks against. It's a mockery of the justice system. What's going on here, in my opinion.
All right. Folks, unless you have anything else, I'll see you all tomorrow morning for 9 o'clock for an anticipated 9:30 start time. Okay.
Thank you.
Today was a 9:30 anticipating start. He showed up. Here's what I've learned from this court, from this trial. Everybody sits there waiting for the judge. He has never, to my knowledge, been less than 20 minutes late, and he has been as much as 90 minutes late. But that today's recap. A 3.5 hour recap. But here's the thing. I pause and I speak. I pause and I speak. And I answer your questions. And so sometimes it takes time. Now, in roughly 4 hours, I need to be at work because it is 3 a.m. here. Time flies. So I need to take a few hours of sleep, go to work, get back home, take a longer nap, and then I will stream tomorrow roughly, maybe a few hours earlier than today. Because, we need to see this. The absolute clusterfuck that is this trial. And why? To raise awareness in Atlanta, the United States, and internationally that these things needs to stop. And the only people who can do that is we, the people. All right, I'm going to send you off. And I know that Danny Ahn is doing a trial here. If you not already, a roughly clean trial, at least. So you get a palate cleanser of sorts. Thank you all for showing up. I will see you all back here tomorrow. And take care of your family. Unless your family is shit, then fuck them and take care of the people who deserves your love. All right. See you around. Bye-bye.